Recording has begun.
It's here.
Good evening. This is the February 25, 2025 regular meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force of the City and County of San Francisco. The time is 4:41 p.m. The Sunshine Ordinance Task Force and its committees convene in hybrid meetings that allow for either in-person attendance or remote participation. Public comment will be taken on each item of the agenda. Meeting decorum. Any member of the Sunshine Ordinance Task Force or its committees may call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Chair LaHood, that completes my announcements.
Please call the roll. Or call attendance, yeah.
I'm calling the roll. Chair LaHood.
Present.
Chair LaHood, present. Member Wolf. Member Wolf, absent. Member Anderson.
Present.
Member Anderson, present. Member Pilpel.
Present.
Member Pilpel, present. 3 present, 1 absent. We have a quorum.
Okay. Are there any agenda changes that we know of?
None that we know of.
Okay. Please call the next item.
Comment?
Public comment on the fact that there are no agenda changes.
Taking public comment on item 1. If there's anyone in the room who would like to make public comment, please approach the podium. Anybody in our online community, please raise your hand in the app or press *3. I'll give you a moment. We have no hands raised and no one in the room.
Please call the next item.
Item number 2. Approval of the January 30, 2025 Compliance and Amendments Committee special meeting minutes.
Okay. I know Member Pilpel has some specific edits, and one thing to note, we do need to say Sunshine Ordinance Task Force on the top in case anybody finds this and needs to know that the Compliance and Amendments Committee is associated with the Sunshine Ordinance Task Force. We have, for those of who have not joined us recently, what we're trying to do is give Ms. Peterson any extensive changes before minutes get posted. Since that didn't happen this time, if we have changes that are more than minor or punctuation changes, I'm willing to hear them, but then I would suggest that we perhaps hold on approving the minutes until an updated version of the minutes is presented publicly, so that we're not approving changes in advance. Does anyone have changes to the January minutes? Member Pilpel.
Hearing what you're saying, let me just summarize. They are, the minutes are only 2.5 pages and the edits aren't that extensive. It adds public comment, none on items 2 and 5, adds a line under item 1 that Member Anderson acted as chair until Chair LaHood arrived. Adds that in addition to the line, the meeting was held in City Hall room 400, I would suggest adding comma, not room 408, because that's what it was advertised as, just so that it reflects that. Adds member before Pilpel and Wolf on item 2 in the action. On the top of page 2, clarifies that it was not Ms. Poe specifically, but the city administrator's office in line 1, strikes the duplicative his request for at the end of line 1. At the end of that paragraph, between the manager and human resources that pertain to him, semicolon, they should not be considered personnel records, period. Reduces some language there. On the second paragraph, Vivian Poe, insert city administrator's office, comma, respondent. Second line there, instead of our human resources team, would read their human resources team. And at the end of that paragraph, emphasize that the request was being treated like any other request that came from the public, period. I think the verbiage after that is confusing and unnecessary. On the action, could replace file 23-100 with the matter. Not a big deal either way. On item 5, the meeting was in recess from time to time. And on item 6, it would read, members of the committee discussed inviting the city's contacts for state legislative work to a future task force or committee meeting to discuss legislative proposals in Sacramento as they relate to the Brown Act and the Public Records Act. I just think it reads more clearly. I don't think this is particularly substantive. If you want to hold off approving, we can do that. I'm comfortable approving with these edits as read. I don't think it changes any outcome, but up to you.
My feeling is I don't think it changes any outcome, but because it's more than 3 minor things, even though, I don't have a problem with any of these suggestions. I think several of them are helpful. Some of them are optional, but I don't find any of them objectionable.
A thought, perhaps since the most substantive change is to item,
Please.
Oh, me or
perhaps since the most substantive change is to item 4, and since we're hearing that later, maybe we could take a moment when Mr. Castiel and Ms. Poe are participating, we could read that back, and if they have no objection.
I don't think that's necessary.
Okay.
No, I mean,
I don't know that anyone else is going to care, but that's fine, whatever you want to do.
Right. My feeling is I just don't, and we've gone through this before. I don't think it's appropriate for us to approve changes that we're not actually seeing if it's more than a few things that I know can be tracked. Member Anderson, if you have thoughts on this or.
I agree with what you're saying. Again, if it's a small change and just a couple, then that's fine. But I think when you get into more than that, then people want to see what's being put in the minutes.
Yeah.
So I would say hold.
Yeah. So I would move to continue approve. And I also feel comfortable doing this because on the whole, the draft minutes are in substance reflect what happened at the meeting. I think we should continue approval of the minutes to our next meeting. And those changes must be submitted to Ms. Peterson in time for her to make those corrections so that we can approve a final version and not have to continue them again. And thank you for the edits. I do think they're helpful.
That's fine. I'm happy to second, and I will submit the edits today.
Okay. Any further discussion, or should we open for public comment?
I'm sorry.
So let's take public comment on continuing the minutes, continuing approval of the minutes.
Shall I read the motion?
Sure.
Moved by Chair LaHood, seconded by Member Pilpel to continue approval of the minutes to the April 22nd, 2024 meeting of the CAC, Complaint and Amendments Committee.
Sure.
Okay. Taking public comment on item 2. Anyone in the room wishing to make public comment, please approach the podium. Online community, please raise your hand in the app or press *3. We have no public comment.
Okay, please call the vote.
Taking the vote on item 2, Chair LaHood.
Aye.
Chair LaHood, aye. Member Pilpel.
Aye.
Member Pilpel, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Wolf, absent. 3 ayes, 1 absent.
Thank you. I realize in retrospect that may have been one of those items that could have been done to the call of the chair, but I don't mind extra votes. So please call the next item.
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda. We have no one approaching the podium and no one online with their hand raised.
Okay, please call the next item.
One moment, please. Item number 4, file number 23100. Complaint filed by Jimmer Cassial against the City Administrator's Office for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner. On February 20, 2024, the Complaint Committee moved to find that the Sunshine Ordinance Task Force has jurisdiction, that the requested records are public, and to forward the matter to the full task force for a hearing. The Complaint Committee requested information regarding why the exemptions under Section 67.21 apply and to determine whether there is a violation for failure to send a representative to the hearing. On September 4, 2024, the Sunshine Ordinance Task Force, moved by Member Stein and seconded by Member Anderson, found that the City Administrator's Office violated Sections 67.21, 67.21 sub B, and 67.27, and ordered the City Administrator to provide citations from the Sunshine Ordinance or the CPRA for withholding the records, and ordered that any outstanding non-exempt documents be provided with keyed citations for any redactions. On January 30, 2025, the Compliance and Amendments Committee found that the published agenda omitted respondent supporting documentation and continued the matter to its next hearing.
Okay, do we have the petitioner and respondent here?
We have both. One moment. I am promoting Jimmer Cassial and Ms. Vivian Poe to panelist. The parties are ready.
Okay. What we'll do, Mr. Cassiel, I'll give you 5 minutes to give us an update, and then we'll hear from Ms. Poe, and we'll proceed from there with some questions from task force members.
Okay.
Mr. Cassiel, can we hear you?
Yes, can you hear me?
Yes.
Okay.
Yes. And I'm sorry, the time again, please.
Let's give 5 minutes.
5 minutes, one moment. Mr. Cassiel, are you ready for your 5 minutes to begin?
I am ready.
Your time begins now.
Okay, thank you, Chair LaHood and members, again for hearing this complaint at the Compliance Committee. Just to kind of briefly go through it again, this started back in 2023, October 2023, when I requested some information through the Sunshine Ordinance test, or through the Sunshine Ordinance, information about me as an employee of the city regarding email communication between a manager at that time and the HR personnel at that time. I wanted to know information about what was being talked about between the two. And so I went ahead and I filed a documents request through Public Works, who basically claimed that they know, because the manager was no longer there, employed at Public Works, they said that they do not have access to any of those emails. And I find it kind of suspect that a high-level manager appointed to a position who has been in that position for 6 years and is now no longer with the department, and they don't have access to her emails of her 6 years being at the department. This is an individual who had filed a court case with a lawsuit with the city, and I believe under the ordinance that any employee who threatens to or files a lawsuit with the city and county of San Francisco, all of their emails will be retained. So I don't know who has access to those emails, but somebody should. Anyway, so moving on, after I was told by Public Works that they don't have access to the emails, I figured, well, let me go to the city administrator's office, because at the time it was the city administrator's HR department that was over Public Works where I work. And so I did the request. Yes, they were very responsive up until they said they're going to get the information to me shortly. And I believe it was 2 days later, I said, please define shortly. And they said that we'll have the information to you later this evening. That was on a Friday. That Friday, I received the information that they were not going to give me any information that was requested. And the reasoning for it was there was no, actually citing no codes, no government codes on why, but basically concluded the requested documents are non-disclosable after consulting with the city attorney's office because they are considered personnel records. Therefore, for privacy reasons, they are withheld. It's important to note that we are treating this request as we would treat a request from any member of the public, which means anything we disclose to a requester, we would also need to disclose publicly to other requesters. I disagree with that. I'm not just John Smith off the street asking for information between a manager in HR and an employee, and I'm none of the three. I am one of the employees. I am the employee. And I'm asking for information pertaining to me and only about me from management and HR. Then they did go on to say that following the same request, we have expressed to our requester that this request is considered closed as of November 17th. Since the requester seems to be requested, we tried to be helpful and inform the requester that he has the option of pursuing the personnel records request. I've done that twice from what I understand of a personnel records request. The only thing that I think that could mean, other than going to my HR department and asking if I could go downtown and see my file, which I've seen everything in there because I've signed everything that's in there, is to send an email to the city administrator's office, basically asking for the same information, but titling it subject line personnel records request. I have that email drafted if that's what I need to do in order to do it not through the Sunshine Ordinance Task Force, and I can go ahead and send that. But suspect is, I imagine there's some there basically because they're not releasing anything, not even redacted. So finally, I believe in October, I received the email that gave me the actual government code section 7927.700 and 7927.705. Looking through the information and the text in all the documents inside those two codes are pages and pages and pages of subcodes.
30 seconds.
And they all basically come down to personal privacy. I don't need anybody's address. They can redact that information. I would like to have this information, and I wish the city administrator's office and the city attorney would stop trying to deny me. Thank you.
Thank you.
Is Ms. Poe ready to give a response?
Yes. Good afternoon, Chair LaHood and other task force members.
Your 5 minutes begins now.
Thank you. And yeah, after the case was heard by the task force last year, our office took an opportunity to review the case, and basically what we have looked at, the responsive documents that were pulled about this request were all personnel records, and they include information about health training and other leave information that are absolutely personnel related. And those records are protected from being disclosed to anyone through the public record request. I think even though Mr. Casio here is claiming those are his records, they are also our department's personnel records. So these are records that are withheld due to really strong privacy protection and reasons. And these are also the conclusion that we have reached after talking with not one, but two city attorneys. One specialized in labor laws. The other one is our general deputy city attorney, and they both have agreed that these records should not be released. I want to point out that public record requests at our office are pretty constant. And there are many times when there are maybe reporters or other people who are interested in our work that have requested public record requests that was sent to us in the past 3 months or half a year. And that was what we meant when we said that that anything that we disclosed to Mr. Casio here, we would have to disclose them to any other parties who would ask for a similar request or just ask for a request that came in the past, year or 2 years. We do have to comply, and if we have released to him, then that means we have to release his personal records to anyone who might have asked for that. So I want to just make sure that I clarify on why we were why when we responded to him that we particularly mentioned that we're responding this request just as any other request, which means, again, if another person asks for it, we have to release his personal personnel records to another party. So anyway, I want to make sure that the task force members understand that we have took the initiative of asking our employees to pull the records. We have pulled the records. We have looked at them. We have looked at them with the city attorney. We have all concluded that these are personal records, and we have cited the government code section 7927.700 and also 7927.705. Those are California government codes, which are the citation that we might have not provided in past communication. But just as Mr. Casio mentioned, after the last task force hearing, we have gotten back to him with the citation as of why we have to withhold those personnel records. That's all from me. Thank you very much for your time today.
Thank you.
So I have a question. Ms. Poe, since the Sunshine Ordinance Task Force issued its order of determination, have you provided any additional documents or have you provided any additional records to Mr. Casio?
We did not. We have concluded all of them are personnel records. Therefore,
did you perform new searches in response to the ordinance? In response to the order of determination?
No new searches, because we have already searched those documents back when we first received them.
Okay. And other than stating what the citations just now, did you provide those citations to Mr. Casio after we issued our order of determination?
Yes, we did. It was in October of last year that we replied it back to him with the citation.
Okay. Members, who has questions?
Member Pilpel here. And for anyone who's watching, I'm wearing my favorite Public Works Mohammed Nuru scandal t-shirt. If you were here, you could see it in person. Never mind. So first to Mr. Casio, the original request that you made that I believe the department summarized on page 43 of the packet, communications between Jason Jimenez and any at sfdpw.org or sfgov.org, jimmer.casio@gmail, jcasio@AOL, which includes the words Jimmer Casio and or Jimmer Casio in the subject body and or attachment in November and December of 2022. Is that what you were looking for and still what you were looking for, including what you discussed a few moments ago about possible litigation and whatever else? But does that still capture what your request was and is?
Yes, it's actually about 2 months worth of emails. I imagine there's not very many of them, very few.
Okay.
So yes.
Let's go with that. So to Ms. Poe, the records that were referenced that you've discussed or that your department has discussed with two different deputy city attorneys, are you familiar with the records at issue?
I am not I have seen some of them, but I
Okay.
can't say I'm familiar
Okay.
with it because those are pulled from our HR team. So we're very careful about not having
Okay.
exposure to our employees' personnel records to too many people.
Okay. Do you know, for example, how many records are at issue or how many pages? I mean, what's the universe here? Are we talking 3 documents, total of 5 pages, 500 documents worth 800 pages, somewhere in between? Can you give me a sense of
It
what's
is my
in
understanding
contest?
it is my understanding it's around 20 to 30 of them.
Emails.
Yes.
Okay.
Or
Um,
I think at the end they might have become PDFs, so I'm not certain that there were a number of emails. I
okay.
think it ended up being like PDF'd it as documents.
Okay. So let's say for purpose of discussion, it could be between 20 and 30, could be more, could be less, but something like that.
Hmm.
Okay. So if that's the universe of what was pulled based on this records request, and your contention at this point continues to be that none of those records are subject to disclosure because they are all deemed personnel files within the meaning of 7927.700 and 705, correct?
Correct.
Okay. So if that's what comes out of the public records search, if, as Mr. Cassiel just discussed, he's got a draft letter asking to review documents as an employee, presumably under whatever rights he has as an employee under the state labor code pursuant to the MOU as a city employee, MMBA, whatever applies, right? Has your department, in anticipation that that might happen, also pulled responsive records on that basis? And would that yield a different universe, a different set of records? Or is it the same records, some of which might be subject to disclosure with or without redactions as a personnel records request as opposed to a public records request? Do you understand the question?
I don't know if I can answer that question.
Okay.
Yeah. Because we were reviewing it as of it is requested as a public record request.
Okay.
So I'm not sure I can answer that question.
Okay. Then maybe where I'm at this point, I understand that you responded, we could talk about timing. It looks like your department's response to Mr. Cassiel in our packet at page 45 was dated October 29th of 24 when the task force order was in September. That was almost 2 months later. In any event, you did cite code sections. That's what we asked for. There's that. I'm just trying to understand, and maybe I'm not going to get an answer today, if there would be additional or different records, or if they would come to the same place. Maybe if you could tell us, from your limited exposure to the requested records, could you describe, without revealing the content, of an example of one of the records that you've identified but not provided, and why you think that's a personnel record and subject to non-disclosure on that basis, as opposed to a public record, that could be provided in a more redacted form? That's what I'm trying to understand.
I mean, as we mentioned, I think we have tried, we have reviewed them, and it's our department policy that we would always respect kind of the public record requests we release as all the time, the most that we can. But these are the ones that we have checked again with the city attorney, and it is my understanding that it is related to Mr. Casio's health information and maybe some leave information and some training information that is sensitive to the individual. So that's why they are part of the personnel records that we have our employees, our staff in the HR team, as well as the city attorney have reviewed them for that conclusion.
Okay, so that makes sense the way you've described it, Mr. Cassiel. Is there something else that's not health, training, or whatever the third thing was that you think may be out there?
Oh, I believe there is. And as far as releasing information about my health training or anything else, I have no problem with releasing it publicly. I have some of the emails because I would probably have written some of the emails that are in there that are included in the results of their search. I have no problem with it being released. All
right. Well, I don't think we need to do privacy waivers here for all kinds of reasons.
Sure.
If you were to pursue if you understand that the department's position is that everything that they've pulled, they've categorized as a personnel record and can't disclose
publicly
as a public records request, but that you may have access. And Ms. Poe, can you confirm that Mr. Cassiel may, emphasize may, not necessarily yes or no, but might have access to some of those records or other records as personnel records if he sends you a thing saying, I'm asking for this as an employee? Is that true?
Oh, it's not with me then. It would be with our HR team.
Okay.
And they would have to decide, because I don't know if any of the personnel records should be, I just don't know what can be released to an employee versus.
Understood. But can you go with the concept of may, as in it is possible that it would yield something? It's at least going to get a response, and the response may say, yep, we've got these other things you can look at, or, for whatever reason, no, and here's why.
Actually, so Ms. Poe, here's my question to you. If you've deemed that these are personnel records and that's why you're withholding them, and they're all personnel records, if Mr. Cassiel goes to the HR department and says, I want these personnel records, they should all be released to him, unless within those records you have records that are not personnel records that are being withheld for some other reason, in which case we need to know what that other reason is.
You're getting, sorry, I want to be very respectful, but I'm just not a labor relations person or have any expertise in that. So I really could not answer that question, whether something is considered personnel records but not releasable to the employees or not.
It sort of doesn't matter if that's the reason you're giving to us, that these are all personnel records. Like, we either need to know if they're personnel records or if they're not personnel records. Because if they're personnel records, then he should have access to them through the other channel.
I again, with all the respect, Chair LaHood, I would not be able to answer those questions, because they are personnel records after the review of our training in our HR team. And again, I'm not an expert in deciding if they are decide to be personnel records, then they are, if they are all, then become open for the employees to access. I'm not too sure.
Mr. Cassiel, at this point, what would you like to do? Would you like to go back and ask for these as personnel records, or are you seeking additional help from the task force?
Well, I guess I would like to understand, like I said, those two codes, that government codes that they gave to the task force, not until January 27th. I had them, yes, in October, thinking that they would have sent this to the task force as well. So there's so much verbiage inside those two codes and so many subcodes, and it all comes down to basically privacy protection. Basically, it sounds like anybody who does a Sunshine Ordinance task request could get a response, no, because of these two government codes and not redacting information, privacy information to protect one's privacy. I have a feeling that it's not, if it can't go anywhere from here, the next thing that I would have to do is send an email, and I'd like Ms. Pope to maybe explain what she means by being helpful, asking me to do a personnel request. I am only assuming that's what it means because I have gone through twice, going down, pulling my personnel file, looking through everything in there. And of course, I've seen everything in there. It's all been signed by me. So we're no longer under the HR system with the city administrator's office. We've since gotten our own HR department. So I would have to deal with, I believe, the HR in the city administrator's office. And I have a strong feeling that if I do go ahead and just ask for personnel requests to see these records and indicate the exact same thing that I indicated in the records request, they're not going to give it to me.
Member Pilpo again. I've got a couple of thoughts. I'm open to.
Pardon me, Chair LaHood, Member Wolf is present.
Oh, thank you.
I'm open to either closing this today because we've done enough and we're not getting any farther. I'm open to continuing this. I'm not strongly persuaded one way or the other. I think at this point, encourage Mr. Cassiel to submit a request, however you want to characterize it, to review your personnel file, to review personnel records, etc. I would encourage Ms. Poe, if we ever get to a thing like this again, that you're doing a fine job as the middleman or middle person. But in the future, if we're talking about personnel records, it would have been helpful to have someone with you today who was either the head of HR or someone who had actually reviewed the subject records, because you're talking in general terms, which is great, but and you characterize the records a little bit, but we really needed to have somebody from your HR team. And then just finally, in the future, again to Ms. Poe, if you receive a request from a city employee and like this, that appears to implicate what you believe are personnel records, I think the best response would be, we have identified X number of records totaling Y number of pages, none of which can we disclose to you as a public records request due to these code sections, blah, blah, blah. However, if you wish to review them as a city employee pursuant to applicable blah, 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 that would yield either this same universe, some of which may be redacted, whatever, here's how you can look at them, or this other universe of documents, because this actually constitutes things that are within your personnel file or are considered personnel records related to you as a person. Please let us know how you wish to proceed, so that you're laying out much more clearly to the employee that there are two different routes and what those searches find. Does that make sense? Sort of.
Yes, thank you for that.
Ms. Poe, I have another question. Would it be possible to, or I guess, as far as, are you able to say whether the records that you are withholding are you able to say whether they're all emails?
I believe they are, because that's what Mr. Cassio kind of request was based off of.
Okay, so here's a question. Mr. Cassiel expressed concern that if he looks at his whole personnel file again, he might not be able to distinguish which items would have been discovered in a search by your office and are not being withheld. Would it be possible for you to provide him with a list of dates for the files that you are withholding, which would allow him then to look at his personnel file and determine which items may correspond to the ones that are being withheld in the public records request.
I can possibly do that, but I was just wondering when Mr. Casio was talking about looking into his personnel records. Do you see emails? I mean, is it part of a personnel records?
Let me, Mr. Cassiel, when you look at, you said you've seen your whole personnel file. Are there emails in that file?
No.
Okay. So if there are not emails in that file, it sounds as if, Ms. Poe, if he goes and asks HR for his file, he's not going to see these records, which you say are part of his personnel record.
I think they're considered personnel records, but I'm not sure is it in like an employee's individual personnel file.
So you're saying that the HR department would have to perform the same search that you did in order to locate the same set of emails, but it's then he essentially would be filing a public records request, or I don't know, an HR records request.
I'm not truly understanding when he's like, okay, I mean, I think he should, it is part of what I understand that our HR team never received an email from Mr. Casio asking for those records or asking for information. I think we have only received the public record request.
Correct. But I did a personnel records request through the HR department where I have to go, where basically you have to request it, schedule it, go downtown. They pull the file. I get to look through it. I can't take copies of anything. I can't take pictures of anything. They can photocopy things that I would like them to photocopy. Everything in there is personnel records. It's all the documentation I signed since I began employment with the Public Works, and it doesn't have the emails that I'm looking for in here. What I'm thinking is, because Ms. Poe was trying to be helpful by suggesting to do a public records or a personnel records request, I'm seeing that as an email requesting the exact same thing I did through publicly, but do it privately through the city administrator's HR department. They're no longer over Public Works, the city administrator's office HR. We have our own HR department. This goes back to when it was the city administrator's office over Public Works for their HR services.
Can I, let me ask two other things to both of you. Is it possible, given the time frame here and the fact that DPW set up its own HR function, that some records were transferred and are no longer housed at the city administrator's office, but got moved to, remind me, is it Ms. Hill that's running DPW HR?
Yeah, it is. These are emails. This is not personnel records. These are emails between a manager and the HR department.
Okay. And just so that I understand, this Jason Jimenez, is he no longer with the city?
He is. He's with the city. He's with HR.
Exactly. Jason Hyman is city administrator's HR employees.
Mm-hmm.
Okay. All right. And it's specifically communication between him and somebody else that refers to you. That's what you're looking for?
Correct.
Okay. And that may or may not be in a personnel file or encompassed within the world of personnel records.
They wouldn't be in a personnel file, and they apparently, according to Public Works, they do not have access to these emails anymore because that individual manager is no longer with Public Works.
Okay. The only other thing I can think of, it goes back to an obscure provision in the Sunshine Ordinance. If someone wants to pull up 67.21C, refers to a statement as to the existence, form, nature, and quantity of records. It's sort of the equivalent of a privilege log for anyone who's listening, that whether or not a document is public, that if someone requests this kind of a statement, that a department has to essentially inventory records that may be responsive, describe them generally, and not provide any of the records, but allow but provide enough detail that a member of the public could make a subsequent public records request for them. That might be the kind of thing that would be most useful here, because this, in a lot of ways, this sounds like we're arguing about terminology, and personnel to you is not the same as personnel to me, or vice versa. And somehow we've got to, I think, find a way to break the logjam. I don't know. Anybody? Anything? Bueller?
Member Anderson, Member Wolf? Member Wolf?
Member Wolf, do you have a comment?
He's not at his chair. Can I add something here?
Sure.
I would be willing, if we want to consider this or call this personnel records, and if I were to do a personnel records request through HR, the city administrator's HR, for these exact documents, I would be willing to have them put them in a folder. I could come down to City Hall to the city administrator's office and review the documents like I would any other personnel records request, and be able to get photocopies of what I want. And I mean, that's how they handle personnel records requests. If I want to see my records, I have to schedule an appointment, go down there, they pull the file, and I look at everything that's in there. Now, if they want to consider this personnel records, then I should be able to do a personnel records request, go down, make an appointment, go down there, look through the records that are in this request, and call it a day.
Ms. Poe, is that possible?
I think I can definitely talk to our HR team to see if they can just produce them. And I wonder if it's, I wonder if they would just pass it to Public Works HR so that it's becomes Mr. Casio.
I'd be okay with that.
Yeah.
I think the goal is to get him his records. I would like to propose that I'd like to continue this matter and here's what I'd like. I would, Ms. Poe, it sounds like you're willing to work with Mr. Casio to see if we can, if he can be given access through some HR function. I would like to have a report back from you if he is able to get access through either your HR department or Public Works HR department. If we get a report back, then perhaps we don't need to have the parties come back to see us again. But if he's not able to get access, then I think we do need to have you come back, because then we need to decide what to do, since it would mean that we haven't had full compliance with the order. So members, how does that sound?
If that becomes a motion to continue to the call of the chair, with the understanding that the file can be closed if Mr. Castiel is satisfied, that works.
Yeah.
With the discussion that we already had, and I would very much like us to come to a better place with how to deal with employee requests for personnel records more generally,
Right.
so that we don't have to. Nothing against
Departments handle things differently. too.
understood, but that we have an approach,
Yeah.
so we can say, you knew this person was an employee. Can you do something like this? It shouldn't matter that they're
Right.
a public works, city administrator, city attorney.
And that would be
employee.
assisting them in getting access to the records they seek.
Right.
Yeah.
This isn't the first time an employee has asked for personnel related records. It's not going to be the last time. We've got 30,000 city employees. Some of them may get laid off in a few months. People are going to be pissed off. This is something we should anticipate.
Yeah. There should be an administrative process
Right.
that employees can go through. That's pretty standard.
Yeah.
So if you want certain things, this is the process you go through to get it.
Right.
And in fact, this is probably a sentence or a paragraph that could be put in the city's employee handbook that says, if you're looking for your personnel records, there are
Follow
a few
these
ways
steps.
to do it.
Yeah.
Blah, blah, blah. Here's how. And that's something that somehow
They have that.
that is in there somehow.
They have that. I can request, personnel records request, and I can make the appointment, go down there. But the thing is, with the things that I'm requesting in here are emails between a manager and HR. They are not in the personnel file.
They're not, it's not part of the standard procedure to put those
Correct.
in someone's personnel file. Okay,
Correct.
so this is, okay. I'd like to make a motion that we continue this matter to the call of the chair and ask Ms. Poe to work with Mr. Cassiol as he seeks access to these records, either through the city administrator's HR department, or if directed through Department of Public Works, HR through Department of Public Works. And if we have received confirmation, I'm going to say from both parties, that access has been granted, we will close the matter. And if not, we're going to ask you to return to a future Compliance and Amendments Committee hearing.
That's your motion?
That's my motion.
I second.
I will need some assistance with shortening that. Hold on just a moment.
Okay, sorry, too many words.
Just want to capture the essence. Moved by Chair LaHood, seconded by Member Anderson, to continue the matter to the call of the chair and instruct respondent to work with complainant
Work with
To
petitioner,
achieve-
yeah.
or petitioner
To access the records,
The requested record.
the requested records through one of the, should we say through,
Personnel records request.
yeah, personnel, through a personnel records request through one of the city's HR departments. And we don't need to spell out the. Through an appropriate city HR department.
make sure I get this. Instruct respondent to work with the petitioner to access the requested records through a personnel records request through an appropriate city HR department.
Sure. Yeah, I think that gets at the essence of what yes.
Okay.
Not for the motion, but to clarify.
Yeah.
To Ms. Poe, Ian, if this passes to operationalize this, I think this might actually require or suggest a sit-down meeting, maybe with Mr. Cassio, with someone from HR, and so that he can be as specific as possible or as general as possible about what it is he's looking for, so that they're not necessarily looking just through a narrow HR lens. But if he says, here's what I'm looking for, here's an example, blah, 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 and they may say, oh, well, that's not in your file, that's somewhere, that somebody helps try to find what it is Mr. Castiel is actually looking for. Because somehow I think there's a bit of ships passing in the night here. And I think you understand now better than anyone what he's looking for, and you may be a helpful translator. Does that make sense?
Yes, my plan is to connect with our own HR team on those first. And then once I have talked to them and have a better understanding of the records, and it sounds like Mr. Cassio is still looking for the same thing as he requested through public record request, I'll reach out to Mr. Cassio for.
And if you need to help set up or coordinate something, it sounds like he's not looking for thousands of pages. It's a needle in a haystack, but you may need to help.
I want to finish the motion.
That's fine.
So we have the first part of the motion, and then the second part being, so the first part of the motion was to assist him, and then and the parties should report back to the task force administrator whether the records, whether the requested records were delivered to were able to be delivered to the petitioner.
They were just successful, in which case.
Sure.
Were delivered successfully.
Yeah, sure.
Split infinitives. Is there a time frame for that you'd like to cite? Or just generally, the parties should report back? Shall report back?
How about a month on this?
Shall?
Shall, and we'll give
Shall.
it a month because I know it involves parties who are not here.
The party shall report back to the task force administrator whether the requested records were delivered successfully to the petitioner. No, I need the date. Shall report back within 1 month?
I'm going to give you a date.
I'm thinking end of March. So they've got a month, end of March, and either they've resolved it and everybody's happy or happier, or we're hearing it again in April.
Yeah, okay.
I'm going to say by March 28th.
Very good.
The party shall report back by March 28, 2025 to the task force administrator whether the requested records were delivered successfully to the petitioner. One moment, please. Let me consult a calendar. March 28 is a Friday.
No, in fact, you know what? I'm actually going to make it March 25th, and I'll tell you why. Well,
I don't-
Close it at our next meeting,
yeah,
task force.
that's what I was thinking. Make it March 25th, and that way we can report back to the full task force if the matter is closed.
One moment. Okay, so posting for, oops, March 25. Let me get to the right month. Let's see, reporting back by Tuesday, March 25, meeting of the task force
No.
will.
No. Just for their purposes, they need to know that we need to hear back from them on whether this has been successful by Tuesday, March 25th. Full stop.
Full stop. The concern was being able to report back that the case has been closed.
No, that they report back to us whether the records have been delivered.
Full stop.
Full stop.
Okay.
So to both sides, you'll,
Just full stop. That's they don't need to know
Okay.
what we would do beyond that.
no,
but
I
for-
just
yeah.
want them to understand that time is of the essence. So the sooner they set up a meeting and figure this out, that would be better for everyone.
I'll send the email with the request to the administrator's office for the personnel records with the exact same request I did for the Sunshine records. And I will copy Ms. Patterson on that email.
Thank you. That would be great.
And Ms. Poe,
Yes.
It's to Ms. Poe.
even
Yes.
better.
Yes.
And their head of
Okay.
HR.
Okay.
All right.
We have our motion. We have our second. Seconder agrees with does the seconder agree with the motion?
I agree.
Okay. If there's no further discussion, I'd like to open for public comment.
Anyone wishing to make public comment on item 4, please approach the podium or raise your hand in the app by pressing *3 or in the app. One moment. We have no public comment.
Okay. Please call the vote.
Taking the vote on item 4. Chair LaHood.
Hear me?
Oh, sorry. You know what? Hold on. Before we call the vote, that sounds like, was that Bruce?
Yes.
We were calling for you earlier and we were not able to reach you. Member Wolf, do you have any comments on the motion?
Yes.
Okay, hold on. We're getting Morse code.
I have a question. I don't know if this throws a monkey wrench in it or not, but it just occurred to me, is there any process outlined in the collective bargaining agreement with regards to personnel files that includes this kind of information?
That's a great question. Do
Well-
we have anyone involved in this conversation today who happens to know that?
You can find that out when he requests it.
And that's what I was referring to earlier, that there's a process, and it sounds like it's already referenced in the employee handbook. There are various procedures. They generally, my understanding is that they generally do not vary by MOU, but the city has a practice. Anyway, these are all things for them to explore in implementing the motion.
Member Wolf, does that address what you were asking, or are you
Uh,
seeking additional
It,
information?
it makes no difference to me. It's just a question of interest.
Ms. Poe, is this something that you're familiar with?
No, unfortunately not.
And the only reason why I ask is because then Mr. Cassiel might be able to engage his union rep to also help.
Okay.
They'll figure that out.
Yes, I hope that whoever is able to help resolve this will step forward or respond when asked for assistance. Member Wolf, do you have any other were you requesting any modification to?
No.
Okay. Since we've had additional conversation, let's make one more call for public comment, even though I don't think we had anyone who wanted to make public comment, but just in case.
Online community, if you'd like to make public comment on the additional conversation, please raise your hand in the app or press *3. And we have no one in the room approaching the podium. And no hands raised.
Okay, then let's call the vote.
Taking the vote. Chair LaHood.
Aye.
Chair LaHood, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Wolf.
Aye.
Member Wolf, aye. Member Pilpel.
Aye.
Member Pilpel, aye. 4 ayes.
Okay. Ms. Poe, Mr. Cassiel, thank you for being here today, and thank you for agreeing to work together to see if we can get Mr. Cassiel the records he's looking for and to resolve this matter.
Thank you very much. We'll see what happens.
You have a good night.
Have a good night.
Thank you. Adjusting the panelists.
Okay.
Thank you.
Okay. Next item, please.
Item 4, file number 24065. Complaint filed by Anonymous, TMR, against the San Francisco City Attorney's Office for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner. On January 1, 2025, the Complaint Committee, moved by Chair Schmidt, seconded by Member Stein, referred the matter to the full task force for consideration of Administrative Code Sunshine Ordinance, Section 67.21, for timeliness, as well as other possible violations. On February 5, 2025, the Sunshine Ordinance Task Force, moved by Member Sugarman, seconded by Vice Chair Stein, found that the City Attorney's Office violated 67.21 and referred the matter to the Compliance and Amendments Committee to follow up with respondent to confirm resolution of the technical issues and production of the requested documents.
Okay. And do we have the petitioner and the respondent both here?
Caller, I am unmuting you. I see a hand raised. One moment. Hello, caller. Are you here for item 5? Excellent. Thank you. We have both parties.
Okay. I'm going to give the petitioner 5 minutes to give us an update. And I see that we have in our packet an update from the city as well and Ms. Quart. So let's give the petitioner 5 minutes and Ms. Quart 5 minutes to give us an update, and then we'll proceed.
Caller, are you ready?
Sure, and I just wanted to ask.
Minutes?
Yep.
All right.
Yes, I am.
Begins now.
Good deal. Thank you, Chair LaHood and members of the Compliance and Amendments Committee. Just one quick question before I give my statement. Did you guys receive the email message and documents that I sent in on Friday? It was after the noon deadline, but I didn't learn of this meeting until about 8 p.m. on Wednesday, or excuse me, I didn't receive a message about this meeting until 8 p.m. on Wednesday evening.
Ms. Peterson, pause the clock for a second. So, Ms. Peterson, did we include the records that the petitioner sent?
Hold on, I have to check the deadline for receipt of supplemental documents.
It was at noon on Friday. I was notified of the meeting. I received an email on Wednesday at 7:56 p.m. I was out of town until Friday after the deadline. So as soon as I received that message, I responded back. But if it's truly I just want to make sure that you guys have the documents, or I need to describe them better if you guys do not have the documents that I sent in. It was my belief that we had to get documents in 5 business days before the meeting, but I wasn't even notified within 5 days of this meeting.
Madam Chair.
Member Pilpil.
Okay, so on page 72 of the packet is the notice of the meeting, and I believe the petitioner is correct that he was notified Wednesday, February 19th at 7:56 p.m. That the deadline was Friday at noon. So that seems like it's not a whole lot of turnaround time. And so I don't know. I assume the documents were received. I certainly haven't seen them, and perhaps they were not included in the packet. But I'm wondering why the notice didn't go out until Wednesday, less than a week before the meeting. It may or may not be material, and maybe if the petitioner just explains the content, that may be sufficient.
Well,
we need to do something else.
I can explain. That's fine. I just wanted to make sure that I do a decent job of describing the issue if you didn't have the
I want to ask
the attachments.
Would you be comfortable proceeding knowing that those are not in the attachments?
Yeah, I want to get this wrapped up. It's been 2 months since I made this request, so I'd like to get this wrapped up, and I hope you'll bear with me, knowing that you guys don't have the information that I sent in.
Okay, so here's what I'd like to do. Ms. Peterson, if we could restart the clock, and I'd like to give the petitioner a full 5 minutes.
The clock has been reset.
And shall
Good deal.
to be ready to begin?
Are you
Okay.
ready to begin?
Yes.
Okay. Your time is
Good deal.
started.
So thanks again, Chair LaHood and members of the Compliance and Amendments Committee. This complaint is related to a public records request I made on December 20th of 2024. And I made my original records request via email on December 6th of last year. Unfortunately, the Office of the City Attorney states they are unable to receive email messages from me. And because my email messages and my request for records were not being acknowledged, I called the receptionist at the City Attorney's office on December 20th to make my public records request. And the request I made to the receptionist was, for the period of the past 2 years, please provide all settlement agreements entered into by the City of San Francisco that do not include a waiver of Section 1542 of the California Civil Code. And then on January 2nd of 2025, more than 10 days after my original request, I received an email message from the City Attorney's office invoking a 14-day extension. On January 13th, I received an email from the City Attorney that states, I'm responding on behalf of the City Attorney's office to your below request. Based on your request, we understand that you are seeking relevant agreements settling civil litigations and not agreements settling administrative actions, i.e. actions brought before the Public Employment Relations Board, the Division of Occupational Safety and Health, etc. A city department has contemplated to impose discipline of a city employee or union grievances. We conducted a diligent search for all such records in our possession, but have found none. So this response from the city attorney, it altered my original records request and did not result in the production of any records. Another member of the city attorney's office had previously informed me that there are in fact responsive records to my original request and gave me a list of responsive records that included the settlement agreement dated February 8, 2023 between Lynn Rawls and the city and county of San Francisco. I was contacted by the office of the city attorney by phone, and this communication was not related to my records request. Instead, I was asked if I plan on attending the Sunshine Ordinance Task Force meeting regarding my complaint. I was informed by the colleague they received an email from their boss instructing them to call me. I was told that if I didn't attend, the city attorney would not have to provide a response to the task force, which is what the city attorney preferred. During that phone call, I made a records request for the email message that asked that the Office of the City Attorney employee contact me. I was informed this is an exempt record and would not be disclosed. Due to the fact that the City Attorney serves as a supervisor of records and Sunshine Ordinance Task Force complaints can be referred to the City Attorney to ensure compliance, I believe the public interest of disclosure of the record outweighs any non-disclosure. And then to date, more than 2 months after my original request, I have not received any responsive records to the original request I made related to settlement agreements that do not include a waiver of Section 1542 of the California Civil Code, despite the City Attorney's letter that's dated February 21st, 2025 to this task force. That letter concedes that there are records that are responsive to my original request. Since I haven't received those records, I'm wondering if the task force has received these records. And that's all I have.
Okay, thank you, petitioner. Ms. Court, we're going to reset the clock and you'll have 5 minutes. And I know you submitted a record, but if you could, for others in attendance, if you could summarize the response, that would be helpful.
Sure.
Your 5 minutes.
Okay. Now, great. Good evening, Chair and members. As instructed, would like to update you on the steps the office has taken since the full task force hearing on this complaint about 3 weeks ago. There's a couple of things. First, we have produced all of the requested documents that we discussed at the task force hearing, and those are in 2 categories. We produced the Lynn Rawls settlement agreement along with the Exhibit A to that settlement agreement that the requester had asked for and brought up at the task force hearing. And then kind of the second category of records that we produced are all administrative settlement agreements that do not contain a 1542 clause. As a reminder, we initially understood the request to be for settlements in civil litigation only. And when we sent an email stating that to the requester, we did not receive anything until these task force hearings clarifying that they did in fact want administrative settlements. But regardless, we have now produced all of the administrative settlements as well. And I think maybe something might have gotten wires crossed with the requester, but we sent him an FTP link to download all of those records at 12:01 p.m. on Friday, the 21st of February. So if he wasn't able to receive those, we're happy to resend them, but we did send that on Friday. The other steps we have taken since the task force hearing, I confirmed with our IT department, we had a discussion about kind of the technological issue that we experienced with, unfortunately not really being able to receive this requester's emails. We discussed at the task force the concept of whitelisting, basically putting an email on kind of like a safe list. And I confirmed with our IT department that this specific requester's email has been whitelisted for a while now. Despite that, their emails keep getting quarantined. We don't understand why this is. As I explained before at the task force, it's Microsoft's kind of AI spam filter. It is constantly changing, and it's not really something that we have control over. We're continuing to talk with our IT department to try and figure out a technical fix, but that's kind of where that stands as of right now. As suggested at the full task force, we did update our public records email address to send automatic confirmation emails when someone sends an email to that address. We've also updated the Sunshine page of our website to let requesters know that they should be receiving an automatic email confirmation when they email us. And the website says to call our office if they do not receive a confirmation email. So that's not a perfect solution, but it's an interim step. And just want to reiterate, we take our Sunshine obligations very seriously, and we hope that both you and the requester can see that we have taken several steps since the task force hearing to provide them with the records that they're seeking despite all of the technological issues. So with that, I'm happy to take questions.
Ms. Court, thank you. Question. What was the email do you know the email used to send that FTP link to the requester?
Yes. So it was public.records@sfcityatty.org. And it was sent at 12:01 p.m. on Friday. That's past your deadline to get things into the packet. Otherwise, we would have provided you a copy with that. And it was sent to tmr408@protonmail.com.
Okay. Petitioner. Oh, sorry.
Peterson.
Ms. Peterson.
I also wanted to provide a quick explanation. So we sent to tmr408@protonmail.com on Friday the 21st.
I'm sorry. I couldn't hear you. There was some background noise.
So on Friday the 21st, we sent to tmr408@protonmail.com a statement that the information had been received after the agenda had been posted, and we were unable to include the materials in the email in the file.
Okay. And petitioner, did you receive the email from the city from public.records@sfcityatty.org on Friday with the link to the FTP site to download the records?
I'm looking right now, and it says that your request, I received an email. It says you will be receiving an email from noreply@sfgov.org with a link to the responsive records. So I do have the email message from public.records@sfcityattorney.org, but I do not have any email from no-reply@sfgov.org that's described in the email message from the public.records city attorney email address.
Okay, I am so happy that we are able to show that efforts have been made. I'm slightly disappointed that you didn't get that second email. But Ms. Court, do we know what happened or what we can do to make sure that, because clearly you were trying to get the records to the petitioner. What do we think happened?
Well, I wouldn't have access to kind
that.
of the end product email to them. So, I mean, happy to send it again, totally. If they want, I can maybe print all of them and leave them at our office. Like, I'll mail them to them at this point, whatever they want.
Okay. Yes, Member Pilpel.
Just jumping in for a second, just so that we understand, I'm a big fan of the universe, not necessarily out there, but at least here. Can you tell us what is the universe here? Is this 3 documents, 200 pages?
How many pages?
Yeah, what are we looking at here?
I don't have in front of me the total page number, but I believe it was like approximately somewhere between 7 and 14 settlement agreements. Each of those had several pages within. So, but it was too large for us to send over email. So
Okay.
it's substantial.
Okay, but it's not 3,000 records. It's like
I don't think so.
It's
No.
probably 100 or a few hundred pages.
It was like less than 24 settlement agreements.
Okay.
Yeah.
Normally, on this point, normally when you gather documents or folks in your office gather documents, do you typically take a quick look through them so that you know what you're actually talking about? And do you actually put them on the FTP site, or is this somebody else that was doing it here?
No, one of our paralegals who works on public records
Ms.
stuff.
Gilbreth or
Yeah,
somebody?
Miss Gilbreth. Yeah, she
Okay.
sent it.
Okay. If there's a way for you to be sure that you get a copy of all of these emails, just so, if you're not originating, just so that everything sort of passes by you and you can say, yep, that was da-da-da, and I can see that actually,
Yeah.
right?
Yeah.
Something. So it sounds like there was a message sent that said you're going to get a subsequent message with the link, and the first one went and was received, but the second one may have gone but wasn't received. Is that
That sounds like
Mr.
what happened.
Petitioner? Does that sound right?
I don't want to make a pun, but maybe it went to spam. I don't know.
Yeah.
So, Mr. Petitioner?
Yes.
Okay, so you did not get a second email with the link to the FTP site, correct?
Correct.
Okay, if the city, from whoever, can send you that link again and you get some, a link to some nifty cool documents, that would be better than not. Yes?
Yes, I expect them to fulfill my records request after 2 months. Yes, I do.
Okay.
Expect that.
And if in fact this yields between 7 and 14 settlement agreements, documents, blah, 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 it's greater than 0, it's not a million, whatever, that might well be responsive to your request. A little late, a little whatever, but it's a thing. That would not seem to you to be outside the bounds of what you were looking for, given the description?
I got to say, I don't really understand that. I when I first undertook filing this complaint, making my records request, I went through the Ordinance Task Force complaint procedures, and I thought that, within those procedures, it says that after our hearing on the 5th of February, where they were ordered to produce those documents, it says compliance is required within 5 business days of the hearing. And so here we are 20 days later, and we still don't have these documents. And I don't understand that. No, I don't.
So
ask Ms. Court.
Ms. Court, what took so long?
I would say, we are quite busy, but it's not been months, it's not been a year, it's been 3 weeks, and we had to basically ask every single team leader. We have 25 teams in our office, give or take. We had to ask every single team leader for administrative settlements. Like, it's not a small search. It turned up a small amount of settlements, but it's not time consuming. We did have to redact certain things because all of the things that turned up were labor employment matters. So there were certain things redacted for privacy. So, it wasn't a small undertaking.
Well, here's the good news. It sounds like the records are ready to be delivered.
Yes.
Do you think it's possible that tomorrow could you ensure that tomorrow that this email is resent, and perhaps could someone in your office, Petitioner, did you give a phone number, or could you call the office at Ms. Court, if you were to give a time when the petitioner could call and confirm whether the email has been sent, could that be done tomorrow?
Could we have the petitioner call? Maybe can I give him my direct phone number and maybe call around like 3 p.m.? Does that work?
Petitioner, would that be acceptable to you?
I prefer to conduct everything over email just so there's a record, because of the way this has gone from start to finish.
Yep. Let's do email confirmations. Petitioner, I would say this, Ms. Court, if the petitioner has not heard from your office by 3 p.m., would that indicate that there's been a problem sending the email?
That would indicate that, yes, for some reason, something has gone haywire.
Okay.
Yes.
Okay. Can I just insert for a
I have a
second?
comment.
How about this? Can I, because we haven't heard from Member Wolf. Member Wolf, go ahead, and then Member Pilpel.
Yeah, just as a IT security professional, anything from Proton Mail moving forward it's going to be captured by any kind of AI antivirus malware.
Member Wolf, can you explain why?
They usually will track various block lists and known websites. And Proton Mail being anonymous, like completely anonymous email, lots of these filters will automatically block them out. So the way you overcome that is by bypassing it. And the way you bypass it is by adding it to a special list within like Microsoft Outlook, if that's what you're using, or any of your email programs. Or you have to let IT know that they need to allow it to pass through. It gets put on an exceptions list.
Right. Was Ms. Court said that that IT said they have whitelisted this particular email address, but that doesn't seem to have resolved the issue.
But AI might, if they're using AI, then it might overcome that. And that presents a much broader, wider issue if that is what the city has contracted and created policy for.
Member Wolf, do you have any other technical suggestions that you think would help get the petitioner the documents requested?
Other than
as quickly as possible?
changing to a different email server, no. And this should be able to be overcome by the city. I mean, there's enough technical staff here to be able to deal with it. The city has a very huge contract with Microsoft and their support team to be able to overcome it also.
Member Pilpel.
I don't have a specific technical fix. All I was going to suggest is if Ms. Court can ensure that the email with the link gets sent to the petitioner, and that the petitioner, either on receipt of that link and successfully being able to download the relevant documents, sends his own confirming email back to Ms. Court saying, I got it, we got it, we're good, thanks, that hopefully gets through both directions of the force field, or that somebody figures out some other way. I'm just looking for confirmation both directions that things are moving. I suspect that Elon Musk is behind all this and he's preventing it, but that, never mind.
I mean, here's a thought, and I don't know if this would help. Petitioner, have you had problems sending emails to Gmail accounts, or do those tend to go through?
This is the only problem I've ever had using Proton Mail. I'm able to communicate with Ms. Peterson just fine about the hearing, so I'm not really sure why this is an issue. I've tried to communicate with the city attorney's office that using the Next Request platform solved this whole problem, or if they used a Google form like the Sunshine Ordinance Task Force website uses, it resolves this whole problem. But that's, I guess I don't understand why that's an issue.
Okay. Here's my recommendation then. Ms. Court, would it be possible to have that email sent tomorrow both to the petitioner's email address and to Ms. Peterson's?
Yes, we can absolutely CC. With the way that the FTP link works, I believe they are going to send, it's going to be sent individually. So we
How
can
about this? Send one to Ms. Peterson as well. And then Ms. Peterson, when you receive that, could you contact the petitioner and say, or in fact, maybe just forward yours to the petitioner. And that way, if the petitioner did not receive their own link, the one sent to Ms. Peterson could be used, yes?
Yeah.
Okay.
That could work for me.
Is there a time limit on the link, on the access to the link?
No, I don't believe so. I don't believe so.
If the link is sent to me, am I able to forward it, and would the link work?
I believe so.
Yeah.
Can you check with your IT people?
Let's just do it. Here, my request is that a link gets sent directly to the petitioner, and even if it's a separate link, it gets sent to Ms. Peterson. And Ms. Peterson, as soon as you get that, if you could forward it to the petitioner and say, I got, this is what I got. Did you receive yours directly? If not, are you able to access the site through this link?
So the link will go out separately,
Yes.
I believe it will, yes.
and I will be confirming that I received a link, that the link works. I'm forwarding it to you,
Forwarding it to the petitioner.
petitioner.
But if you CC Ms. Court too, that would make sure
better.
everyone knows that it's been
Copy
delivered.
Everybody, yes.
Even better.
Yes.
It
Okay.
It sounds like the city has whatever protections on the SF
It might be,
.org. What do we call that? Mail server that's different from sfcityattorney.org. And
Maybe
you've
that's
got
what
a
it
heightened
is.
and
We,
different thing.
we do have a separate kind of like, we both use Microsoft, but like we have a separate kind of, our IT infrastructure is somewhat separate in certain ways that I
Okay.
don't fully understand, but
and the settings might be separate on yours. I think, and Ms. Peterson, I know this puts extra work on you, but it sounds like this would be the fastest way
I think so.
to ensure that the link is getting delivered and that we can get confirmation from the petitioner.
Yes, I think. So.
Petitioner, I know that I'm sorry that this has taken so long, but does this description sound like it would satisfy confirming with you that you're receiving the link to the FTP site?
I really don't have a choice. Like I said, I expected to receive these records after 5 days after the hearing on the 5th, and we would have all those wrapped up by now at this point in time in the evening. But because they didn't follow the order, here we are.
Right, or they attempted to, but and I hear what you're saying, because even if it was sent on the 21st, that was not within 5 days. So you are correct. My goal right now is to move things forward as quickly as we can from here. And I'm hearing from Ms. Court, this will be done tomorrow.
Yes.
Okay. And Ms. Peterson understands her role in this. I would like, I guess, I'm going to make a motion that we are asking the city attorney's office to resend the FTP link to the petitioner and to the task force administrator before 3 p.m. on Wednesday, February 26th. Our task force administrator will confirm that the petitioner has received the FTP link.
Is there a second?
Second. Can I just
Member Pilpel.
comment to that? I think that's fine. I'm not sure that one needs to include it in the motion, but I would appreciate if at the end of the day tomorrow, after whatever happens, if you can get a final email from Ms. Peterson to you, Chair LaHood, saying this is what happened, and that Ms. Peterson heard from the petitioner that, in fact, the records were received. I think by the close of business tomorrow, you should have something that says what happened. That would be nice.
And not include that in the motion.
Right.
You said you do want to include that in?
Not necessarily
No,
to include
it's
it in
okay.
the motion, but just to
Ms.
make
Peterson,
that
I'm going to check in with you by the end of the day tomorrow, and we'll know that this happened.
That's
What I don't want, I do want to leave, I don't want to close things out yet, because I want to make sure that when the petitioner sees the records, that the petitioner says, yes, these are the records I expected to receive. And so petitioner, once you've seen the records, I'm going to leave it to you to follow up with Ms. Peterson as to whether you've received what you were looking for and that compliance has been satisfied, or if you think we need to meet on this again.
So to that end, maybe.
Understood and disappointed that we couldn't have that discussion this evening since they didn't produce the records in time.
I hear you. Member Pilpel.
So to that end, maybe we should add to this motion to continue it to the call of the chair with the understanding that you have the ability to close it if that's all satisfied. If not, this should be back before us again, if there's a need to further discuss.
I don't know that it's sort of, that would be if what we're asking for doesn't happen, or if the petitioner tells Ms. Peterson that he's not satisfied, the implication is that it comes back to us.
Right, but I think that in terms of action on the file,
Okay.
that it's continued to call to the chair with this specific ask for stuff to happen tomorrow. similar to the previous item.
Okay, further scheduling, the matter is otherwise continued to the call of the chair.
So the action is to continue the matter to the call of the chair, contingent upon asking the respondent to resend the FTP link.
No,
No, start with the motion is, my motion is that we're asking the city attorney's office to do the thing that we asked them to do.
To ask the respondent to resend the FTP link to petitioner and the task force administrator before 3 p.m. on Wednesday, February 26.
Yes.
The task force administrator will confirm that
We'll confirm receipt
receipt of the FTP link and confirm
and
that what was
and
sent
forward
was
it
sought and forward it.
and forward it to the petitioner.
The task force administrator will confirm the petitioner has received the link.
Or the task force administrator will forward the link to the petitioner and confirm receipt. Or confirm that it has been received.
So I'm confirming that the petitioner has received my forward.
Yes.
And
It kind of doesn't matter. If the petitioner gets it from someone and is able to access the FTP site, that is the most important thing.
Correct.
okay. So no specifics, confirming receipt of the FTP link and confirm that what was sought is what was received. I was hearing conversation that
Okay, let's say period. Confirm receipt, period.
Receipt, period.
Okay.
That's fine.
Receipt of requested document.
Well, it's receipt of the link. And then furthermore, the petitioner will, furthermore, we ask that the petitioner confirm with the administrator whether the documents received were those sought in the initial request. Or the records received. Yeah.
okay.
And
then-
finally, that the matter is continued to the call of the chair.
And then parenthetically, you and I will
We will talk.
connect at the end of the day
Yep,
about the status.
yep.
Okay.
Let's read it back one more time.
Moved by Chair LaHood, seconded by Member Pilpel, to ask the respondent to resend the FTP link to petitioner and the task force administrator before 3 p.m. on Wednesday, February 26. The task force administrator will forward the link to the petitioner and confirm that petitioner has received the FTP link. Furthermore, we ask that petitioner confirm with the task force administrator that the documents received were those sought in the initial request. The matter is continued to the call of the chair. Separately, the task force administrator will check in with the chair regarding the status of the day's activities.
Yeah, I don't know that needs to be part of the motion. The last sentence, that's just between you and me.
Just
Yeah. Okay,
But I'm gonna do it.
do we have a second?
We do.
Member Pilpel.
Okay. Members, any further comment on this, or should we open any further discussion, or should we open this for public comment?
We can discuss this.
Okay. Is Member Wolf able to?
I may have another comment on the underlying matter, but as to the motion, I'm fine. And
Okay,
do that.
let's deal with the motion. Is member
I've got
Wolf? Yeah.
no comment.
Okay. Okay, do we have any public comment on this motion?
We have no one in the room. One caller, one moment, please.
Well, we do have someone in the room, but not making public comment.
Caller, if you'd like to make public comment on item 5, please raise your hand in the app or press *3. We have no hands raised.
Okay, let's call the vote.
Taking the vote on item 5, Chair LaHood.
Aye.
Chair LaHood, aye. Member Pilpel.
Aye.
Member Pilpel, aye. Member Wolf. Member Wolf, your vote, please.
Yes.
Member Wolf, aye. Member Anderson.
Aye.
Member Anderson, aye. 4 ayes.
Okay, the motion passes. Thank you to the petitioner and the respondent. We appreciate you working to get this resolved. Petitioner, I'm sorry that that this wasn't resolved sooner, but we appreciate your patience, and we will confirm that you have these, that you have access to these records tomorrow. Member Pilpel, you said you had some other comment on this matter?
Yeah, just 2 quick things with Ms. Court. Since you referenced in your earlier comments that it was difficult with the various teams to, or not difficult, that it was a thing to work with the various teams to get this. Is this, in your experience or in the experience of your office, the first time that you've gotten a request for this kind of disclosure of all agreements that didn't include this language? Was this somewhat new and slightly unusual? It's not a bad request. I'm just asking if this was something that people hadn't dealt with before in this way.
In my time, I haven't
Yeah.
seen it, so.
Okay.
Yeah.
But in the event that someone else asks, they've gone through the drill once, they would be able to pull it sooner, presumably, maybe?
I mean, if there were, it still requires them to
Yeah.
go through individual settlement agreements and read through every individual settlement agreement. Because if a new one comes up,
Right.
they still would have to check, does it include this language?
And most do, but not all do for whatever reason.
Most, yes, most include the language. And then a few of the administrative settlements did not include the language.
For whatever reason.
Right.
Okay. All right. That's helpful to know. I did not know the difference between civil litigation and these administrative. There are settlement agreements to administrative actions that happen, however, wherever they happen. It's just, okay, that's cool. Thank you. And then to your other big graph here, thank you for making the change to the website. I believe the phone number was wrong. Perhaps you'll catch that and fix that if that hasn't. But I appreciate your working to upgrade. When we find things where you can upgrade procedures or tweak language, I appreciate your cooperation in doing that with various folks in your office. Thank you.
Okay. Petitioner, Ms. Peterson will be checking in with you tomorrow. Do you have any other questions regarding the process?
No, just to state, just to comment on what I just heard, that throughout the 2 previous hearings of the Sunshine Ordinance Task Force, the city attorney's office vehemently denied that there are any civil settlement agreements that didn't contain that language. And I just want to add that the Lynn Rawls agreement is a civil matter, and I'm hoping that that's included in the link tomorrow. But that is something that's not an administrative action. That's a civil action.
Okay.
And so I'm hoping that that's one of the documents that's included.
Yeah, and I believe Ms. Quart said that at the beginning, and I will tell you she is nodding yes, so that should be one of the ones that you receive.
Okay.
Okay. Thank you, everyone. I believe, members, unless any other comments from you, I believe we're ready to move on to the next item, but I want to ask if we should take if people need a short break or want to proceed.
A short break would be appreciated.
Okay.
I would appreciate a short break.
Okay. I'm going to get, it's 6:28. How about 7 minutes? Okay. We'll be back at 6:35.
Thank you. Microphones are off.
Thank you.
Microphones are on.
Thank you. Ms. Peterson, could we please take attendance again as we restart the meeting?
Taking the roll, Chair LaHood.
Present.
Member Anderson.
Present.
Member Anderson, present. Member Wolf. Member Wolf.
Maybe.
Yes, I'm here. Couldn't get my mouse to get unstuck. Sorry.
Member Wolf, present. Member Pilpel.
Present.
Member Pilpel, present. All present. Four present.
Okay. Thank you, everyone, for being here. And if I don't know, we have a member of the public in the audience. I don't know if we have any other members of the public online. But just to...
We have no one online.
Okay. Well, if anyone joins us, or for those who are listening to the recording later, what we're doing is reviewing the Sunshine Ordinance section by section, and we're having discussion about suggested updates, edits, modifications. We are now starting, we're in section 67.24F.
May I
Yes,
read
Ms.
item
Peterson.
6?
Oh,
into the
I
record?
think that's a great idea. Sorry, I jumped ahead.
Item 6.
Ms. Peterson.
Hearing. Review of Administrative Code Sunshine Ordinance, Section 67, beginning with Chapter 67.24, Sub F, and possible amendments to recommend to the full task force.
Thank you. So here's my recommendation. Since when we look at F, G, H, and I, these are all relatively short. What I would like to do is let's give ourselves 2 to 3 minutes to read this. And then what we'll do is, I don't know, is that Member Wolf's? Yeah, we're here getting a lot of feedback.
It was.
Oh. Member Wolf, just to let you know, I think we're putting you on mute just because we were getting a lot of feedback, but please.
I put myself on mute.
Oh, thank you. Thank you. Okay. Let's take 3 minutes to read F, G, H, and I, and then we'll have a discussion and we will take public comment on that block. So. Yes, I will read that again. 67.24F, which is way down because the ones above it have many, many, many subsections. Yes. Bless you. Okay. Was that enough time, or do you want a few more minutes? Okay. Starting with F, the one thing that jumps out at me is when when it says other than payments for social or other services whose records are confidential by law. I can guess what this means, but this seems rather vague to me. I'm assuming meaning social services. If anyone has insight into what is meant by this and how we would clarify that, that would be helpful. And then in G and H, we do have references to the California Public Records Act. And because of recent changes, we may need to check, these numbers may need to be updated.
Mm-hmm.
But does anyone else have any comments or thoughts on any of these sections?
Yes.
Member Pilpel.
Okay. So starting on F, I have no quarrel with the fundamental concept. I mean, this goes back to the beginning of Sunshine, that there is no reason locally why any budget or financial information shouldn't be disclosed. That's all public record, pretty straightforward. On the social or other services, I would just strike the three words social or other. So it would read other than payments for services whose records are confidential by law, comma, shall not be exempt from disclosure. And then I would just end it there. I don't like the under any circumstances. There may be circumstances, but at least for this section and just in general, shall not be exempt from disclosure, period. I'm not even sure that how operative that provision is, just because you're paying for services, the name of the vendor, if you will, or the payee.
Mm-hmm.
I mean, unless it's actually paying a victim of domestic violence or something I can't quite conceive of, if it's just paying an entity that provides services to domestic violence victims, the fact that we're paying somebody 200 whatever,
or that you're paying someone for psychiatric services,
right.
It would not include the name of the person receiving the services, but it would include that the city is paying this person or
XYZ
entity to provide
XYZ clinic. Yeah.
Mm-hmm.
One of those things where for the police department,
Mm-hmm.
if you're paying
Right.
for an informant.
A confidential.
I see.
You're not gonna.
Yes.
That's fair. Right.
Okay.
So there may be specific examples,
Yeah.
but the general rule is that whoever's the payee, we disclose that, unless for whatever reason that's already been made confidential elsewhere. And that would seem unusual. At some point, I think when we talk to the controller about the fiscal provisions here, we should say, walk us through your vendor payments system, give an example of, a big construction contract or a small payment or whatever. How do you find that? How are those parsed? Right? There's new tools that exist now. They can explain that.
Where it says services whose records are payments for services, it shouldn't be payments for services for which it's not whose service, in any case. Do we want to say are confidential by law such as? Do we want the examples in here?
No.
Okay.
It makes it too specific.
Yeah.
Okay.
And again, when we come back and talk about some specifics, they may say the way we've interpreted that is confidential informant, blah, blah, blah.
Mm-hmm.
Let's have them explain it. And if we need to clarify it further at that time, we can do that. I think for what's there now, it's good enough.
Comment.
Member Wolf.
So what's at issue I usually find with budgets is the granularity of the budget. And a lot of what gets disclosed is not actually a budget that is helpful to a lot of people because it isn't granular enough. And the question that I have with regards to this is whether that should be identified or not. Because otherwise, the real budget is not a line item budget. It is mostly a kind of very it's either very broad or very categorical, and it doesn't really lend to, providing any kind of real information. But the budgets that are line item are still public documents, and those usually are very difficult to get a hold of from any department.
Do you want to say budgets, including line item budgets, whether tentative, proposed, or adopted?
Sure.
Okay.
Well, may I?
Mm-hmm.
I think that the intent of this broad language is that, in fact, it's any level of budget that exists. So if you just want to know how much the city is receiving and spending a year, I don't know what it's up to, 15, 16 billion, blah, blah, blah. That's useful for not too many purposes. If you say I'm interested in this, that's why the words project and program are in here. I'm interested in this particular program or this specific project and the detailed budget for that.
Mm-hmm. And they also say, as well as records of actual disbursements showing the amount paid the payee,
right,
and the purpose for which the payment is made.
So there are really two subsections embedded in here. One is
it's budgets versus actuals.
Right.
Yeah.
That's correct. Okay. So and again, when departments come in, if they say, oh, we don't think this means we need to go recreate the budget in the way that the person asked for it. And we may say, okay, that's fair. This isn't asking that you create a new record, but if you have a way to query a report just for this project or just for this thing or whatever, then that's something that you have to pull within the system that you already have. You don't have to recreate the system, but if you're able to pull a thing for a project because that's how you control the revenue and the expense, that's what this is asking. So I'm not sure.
You want to say including existing line item budgets, or are you saying that you don't even know that we need to include that detail because budgets are budgets?
Right. I'm pushing back against saying line item and just saying that this broad language means whatever they've got about the budget at whatever level it exists, if someone asks for it or if they can pull it, and you sort of take this with other sections, if it's easily generated, the departments already have it, not creating a new record, using existing systems.
Member Wolf, does that
reality.
satisfy? What?
It's not the reality of the way our city works.
So give
Come
an
budget
example.
Come budget time, you ask a department for their budget, and you'll get a very broad level, categorical type of budget that doesn't provide you with enough information. Doesn't provide anybody with enough information.
So give an example. What is it that you might be looking for, or that one might be looking for, that you think is insufficient? And let's noodle through it.
A line item budget, the budget that the mayor receives, where she or he can draw a red line through it. That budget, that doesn't get revealed that often at the department level.
Bruce, I have a question.
Yeah.
If you request a line item budget, are you saying that the department does not provide a line item budget?
Correct.
What, does it not provide it, or is it not what it's publicizing or posting on its website, which is a different
It's not what they when you ask for it, it's not what they disclose.
And if you ask again and say, well, thank you for sending this, but I want the detailed budget, do they refuse, or do they say it doesn't exist? What do they say?
They usually say it's not, anything more granular is not disclosable.
Okay. Bruce, you and I have been at this some years. I have reviewed, computer printouts, binders and binders, pages and pages, levels of detail that you and I might appreciate, most people may not, whether it was categories, objects, sub-objects of revenue or expenditure, project level details, program, divisions, index codes. I mean, it depends on the year and the budget system and the input codes and whatnot, but I've gotten all kinds of levels of detail, and it depends on who you find and how you ask. And what this is saying is that it's all public. And I don't think we can, hold on, I don't think we can or should in this ordinance specify the level of detail that the city handles its financial affairs. That's covered in other articles in the charter and other sections in the admin code. And that gets very complicated with how the city does its accounting and financial reporting. I think what this is saying is that whatever exists by way of budgets and actuals is subject to public disclosure, period.
All right. I understand what you're saying, and I hear you. I've received certain, like if I asked for a line item budget on a particular program or project or something like that, I might receive it. But come the way you would, I've always gotten complaints from the members of the public from come budget time, is that they don't know how a department, how it gets budgeted from the get-go. That you end up with this big number and there's no granularity to it. And then you ask for it and they say they don't have it. Well, they got to come up with it through from some granularity and some analysis at some point.
Yeah, Bruce, I hear what you're saying, and I believe that people are running into those obstacles. I wonder if that is a problem of departments not responding to records requests the way they should.
Not that the law is bad.
Right, or not that these don't exist, or that some departments may be responsive and others are not. Here's what I'd like to do. I added in the clause including line item budgets, and then I'm putting a note, Member Wolf requests this addition, Members Anderson and Pilpil don't think it's necessary. I would say let's keep going and see if they're just so we can make some headway. Would everyone feel comfortable with that? So the annotation is made. Okay.
I have just two brief things on that. To Member Wolf, so as a couple of examples, in your neighborhood, somebody might be concerned with some MTA project, or there's a big building, nearly completed a couple of blocks from you, right? Somebody might say, I want the detail on that project. Okay, I read this to mean to the extent that they've got a project level detail, they got to provide that. Someone might say, hey, I'm interested in your staffing and your costs for the neighborhood library near you. And the library may say, that's hard to do because staff are like 2 days here and 3 days there. And, we could give you an approximate total for your particular branch library, but it's not going to be exact because we don't budget it on a branch library basis. And you may say, well, that's ridiculous. And they may say, I'm sorry, that's just how we do it. So there's a lot of color and flavor to this. And anyway,
my interest is more from an investigative level. So where folks are trying to, members of the public want to see how government works, and they want to see where there's fat or chafe, that they have the ability to ask for that information and get it.
They do. They should. Again, when we get to the finance people, I absolutely believe we will call them in and say, if someone asks for blah, 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 what can they get? We will come back to this. This is not going. Okay. Budgets in the city are not like going away tomorrow.
Okay.
The other thing I had is some specific edits here.
Okay.
So what I would put is on line 2 or any, I would just say capital D department, not
capital D.
Well, all right. I defined it earlier with capital, but that's fine. All right. Or any department, program singular, project singular, or other category. I didn't see
no,
any
I
of these
think you
needed
need,
to be.
No, it has to be a city, because otherwise, I think it is. I actually think the way it is,
all right,
is correct.
That, fine. Yeah. Okay. On the fourth line, I had a couple of commas inserted here.
Well, I inserted a comma after obligations.
All right. How about after proposed on line 1? Tentative, proposed, or adopted? Or are you the?
Nope. No Oxford commas.
You're with the other style
Correct.
convention?
AP style.
Any,
Gotta support AP style, especially these days.
any particular golf you prefer? Never mind. Line 4, payment obligations. I would just say, or actual disbursements.
Hold on, line 4.
Payment obligations or actual disbursements. You can think about that.
No, comma, as well as records of, sure.
All right. I was just trying to shorten.
As well as, sure. Okay, so we're changing it to vouchers or other records of payment obligations or actual disbursements showing amount paid, sure.
Then after the payee, I'm assuming that vouchers, records of payment, that it could be prospective or retrospective. So I was going to say, and the purpose of the payment. I didn't like the purpose for which payment is made. That seems icky.
Okay. Yep. The purpose of the payment. Yep.
Right. And then the rest of it we talked about, other than payments for services, shall not
Services for which records are confidential by law.
Comma, shall not
Yeah.
be exempt from disclosure.
Period.
Yeah, good. Okay, so that's what I had on F.
Okay.
Okay, moving on to GHI. In general, I think that these GHI sections should be moved to 26 or 27 because the whole concept otherwise in 24 was to provide for specifically, if not abrogated is not the right word, to supersede state law as to specific categories of information. And GH and I don't really fit. They're more broadly about disclosure or justification.
So you said to section 6720.
6 or 7. I'm not sure which. I'm not anti the language specifically. It just seems like it doesn't fit with the other things that talk about specific categories.
Yeah, that seems I can go with that. The only I mean, this section is specifically of what must be disclosed.
Yeah. And even though this is the opposite, this is saying, well, it is saying what must be disclosed. It's like you can't use these things as, you can't use CPRA section
Whatever.
whatever as reason not to disclose.
Right. But that's what 27 is all about, is justification for withholding. And so I think somewhere in there,
But
saying,
this isn't justification. Essentially, we're saying this is not justification for withholding.
that's the point. Is it? And I think there's already. No, there isn't. Anyway, my point was to have one section, whether it's 26 or 27, that says, here's how you justify withholding. And by the way, you can't use these sections or these bases for withholding. You can't use them. This is different from these categories are public. The A through F are really categories of thing that have to be public, not broad bases for non-disclosure.
Okay. I'm highlighting it saying, member Pilpel suggests moving G, H, and I to section 6726 or 6727. Member Wolf agrees. Chair LaHood is not sure, reserving judgment until we get to those sections. Member Anderson, do you have any annotation on that?
What you just said.
Okay.
Okay.
Wait till we
One point on I is a balancing test. And I don't know if that, I mean, that should kind of sit front and center somewhere.
Oh, I'm not saying that these sections should be buried. No, they should be front and center. If anything, maybe they become ABC or some version of them becomes ABC elsewhere.
Okay. Let's keep going so we can make some progress. Member Pilpel, anything else?
Okay. I believe, hold on a second. Okay. The 6255 reference in G, the new site is 7922.000.
7922.0000. And is it?
123.000.
Got it. Okay. And I'm assuming that's the same for the second one?
For H.
For H?
Yes.
Okay, great.
And I think I haven't quite figured out the wording, but I think there's a way to combine G and H so that it so that it's only in there once. I think the first cut that I had would read something like a department may not withhold a public record based on a deliberative process exemption or a finding or showing that the public interest in withholding outweighs the public interest in disclosure pursuant to California Government Code Section 79.22.000 or any other provision of law that does not prohibit disclosure. And I'm still tweaking the language, but I think there's a way to combine both ideas in G and H into the same, that you can't use deliberative process and you can't use the general balancing test.
Okay.
That seems,
Do you want me to read that back to you?
No, I think, okay, because I'm looking at, so neither the city nor any office, employee, or agent thereof may assert California Public Records Act Section 7922.000 or any similar provision as the basis for withholding any documents or information requested. No. Hold on. Or any similar provision or a deliberative process exemption.
I had that first, but
Okay.
it can go either way.
Hold on. So you want that? Sorry, when you say first, where did you want to put that?
Do you want me to just read back?
Yeah.
Okay. So I had it, I'm trying to streamline out some of this language. I have a department may not.
Hold on. Why do you want to? I think neither the city nor any office, employee, or agent thereof. Leave that as it is. And then.
Well, okay. I mean, at some point we come back to the concept of who's making the choice, and I think it's a department that's choosing.
No, departments are not people.
No, but they're the ones that are charged with.
Okay, let's fix the other parts first.
Okay,
Where do
fine.
you want deliberative process? exemption?
Whoever may not withhold a public record. End of the first line.
Okay. No. Okay, so no.
You can leave.
Hold on. May withhold. So we're saying neither nor may withhold a public record. Okay.
That's right.
Record
That's fine.
by asserting.
No. I would
No.
just say neither nor, fine, may withhold a public record. Strike a bunch of stuff there based on a deliberative process exemption.
Okay, that's what I'm asking. Okay. Or by asserting.
Or a finding or showing.
What? What are you talking about?
I pulled part of that from I.
Yeah, this is going to get really confusing,
No,
and I think
it's-
it's too many things in.
It's not actually. Just give me a second here. a little rope, and then you can hang me with it, based on a deliberative process exemption or a finding or showing
that the public
that the public interest in
withholding
withholding outweighs the public interest in non-disclosure.
No, in disclosure.
No, that, or finding or showing that the public interest in withholding outweighs the public interest in disclosure.
Yes, that's what I said.
Okay, fine.
One more time, please.
Okay, let me read this.
Yeah.
Neither the city nor any office, employee, or agent thereof may withhold a public record based on a, quote, deliberative process exemption or a finding or showing that the public interest in withholding the information outweighs the public interest in disclosure by asserting California Public Records Act Section 7922.000 or any similar provision as the basis for withholding any documents or information requested under this ordinance.
Yeah, that's still longer than I would do. I would just say at the end, or any other provision of law that does not prohibit disclosure, period.
Did you
Some of
include,
that, but I clipped it at a point.
did you say an exemption for withholding for any document or information based on deliberative process?
Let me read it again. Neither the city nor any office, employee, or agent thereof may withhold a public record based on a deliberative, you know what I think we need? I think we need bullet points based on one, a deliberative process exemption, two, a finding or showing that the public interest in withholding the information outweighs the public interest in disclosure. There's got to be a third thing here.
Well, there is. And if you look in B, it says for withholding for any document or information based on a deliberative process. So the way I read that is it's for any document, which is one object, or information based on a deliberative process exemption, which is another object.
Okay, so we should say withhold a public record dash any document or information based on a.
Well, you could say just say public record.
That's what I had. I had withhold a public record based on.
But public record is independent of information.
Okay, a public
around
record or
deliberative
information.
I was trying to use throughout the term public record because there's a definition here and there's a definition in state law of public record. I wasn't trying to tease out documents or information.
But if we're trying to compress these three, we need to make sure we're not leaving anything out. So at this point, I have neither the city nor any office, employee, or agent thereof may withhold a public record or information based on a, quote, deliberative process exemption or a finding or showing that the public interest in withholding the information outweighs the public interest in disclosure by asserting California Public Records Act section, blah, blah, blah. And then what was after that you changed, or any similar provision?
Of law that does not prohibit disclosure.
But that sounds like it's all based upon deliberative process. When in G doesn't talk about deliberative process, it talks about any document. G and H are independent of each other, specifically because G is just any document or information, whether it's deliberative process or not, doesn't matter.
Yeah, you know what?
H just
I
narrow-
don't think we can
H
compress
just-
these.
H is an enhancement of that by saying you must also provide documents that are based on deliberative process. The deliberative process exemption.
I can go back and parse the language some more, but the concept that I was advancing is that you can't use deliberative process, nor can you use a finding or showing
Right.
that non-disclosure somehow outweighs disclosure.
Right.
And that concept, that second concept, comes out of 7922.000.
To be honest, even though I understand that you're trying to use fewer words by compressing these things, I think it's actually going to confuse people, and I think we should undo this compression. I would rather undo the compression and simplify the language in each one
Why
because
don't we start with that, and then if we find a way to combine them some other day,
yeah,
that's fine.
yeah.
Okay,
So
I
let's
can live with that.
okay. I'm going to undo. So currently we have, okay, as it stands, neither the city nor any office, employer, or agent thereof may assert California Public Records Act section now 7922.000 or any similar provision as the basis for withholding any documents or information requested under this ordinance.
Okay, so let's edit that.
Okay.
Instead of CPRA, let's call that California Government Code.
Why not CPRA?
Because it's not the whole act. We're referring to specific code sections.
So California Government Code.
Section.
Yep.
7922.000 or any, I don't know about similar, but we'll leave that for the moment, or any similar provision as a basis for withholding any public record, period.
But I think Member Wolf was saying information is separate. Any public record or information requested under this ordinance?
Yeah.
No, what I was saying is that a withholding for any document is separate from information based on deliberative process.
Okay, so don't change it in this one. So withholding any.
I think I'm comfortable for withholding any public record, period.
Sure. Now,
in G as we're futzing with it.
Okay, and then delete documents or information requested under this ordinance.
Right. That's what's at issue.
Okay.
Yeah.
Now, I have a question.
Mm-hmm.
Somebody give me an example of a deliberative process exemption. I'm not sure I know what that is or what it means.
There was a concept for that in the 90s. I'm not sure if it's currently codified in state law or if it's an old AG opinion. This was the governor's office, the mayor's office, we haven't decided, we're reviewing applications, and because we've got a bunch of applications and we've got notes about those applicants and applications, we don't want to disclose those notes because that would reveal our deliberative process about those applications through the notes.
Gotcha.
And we're saying no. If you're making notes, if you're analyzing, if you're doing a thing, that's public. But what this ends up doing is people then don't, write them down. They just do it some other way. They text it to themselves and claim that it's not a text that's disclosed. Whatever. I'm just saying.
I got you.
Yeah.
Okay. Moving on to H, keeping it separate from the others.
Yep.
You can replace for any document or information then to be public records.
Okay.
For any public records based on a deliberative process exemption.
Yep.
Either as provided by California Government Code section.
Right.
Yeah.
I would balk against that if there was going to be some combining of G and H.
Okay.
And I'm not sure how much I care. I'll go back and think about it.
Okay.
Yeah, the reason why I'm asserting that is because you can read this two ways. You can read it, thereof may assert an exemption for withholding for any document, or let's say any information based upon deliberative process exemption, which would be two separate objects. Now, somebody else, an attorney or whatever, could interpret it by saying, for withholding any document or information based upon deliberative process exemption, meaning that any document or information specific to that exemption, like combining document and information together.
Well, the way it was written, it's document or document based on a deliberative process exemption or information based on a deliberative process exemption.
Right.
The modifier applies to both.
But there have been arguments that would people would say, well, their understanding of constitutional or legislative construction would mean that they're independent of each other.
Okay, so I think we resolved that by saying
Public record.
neither may withhold a public record based on So we're just simplifying it to public record.
Right.
And we were agreed on that.
Yeah.
Okay, and just to be clear, are we leaving or any other provision of law that does not prohibit disclosure?
For the moment.
Okay. Okay, moving on to I.
That's the balancing test.
Okay, should we change any document or information for any public record?
Yeah, that's fine. Now, let me ask you, are we considering verbal information as public document or public record?
No, in which case we should keep information in.
Hold on.
Okay.
We had a definition. I proposed an updated definition on oral public information. All of that is captured in 67.22. We can go back to that at some point and futz with that, but that's really the only place that oral public information is discussed.
Mm-hmm.
I think I'm generally with the public record concept, except in 67.22. And I guess I would like to hear from Bruce or others here why we need the first sentence in I if we're keeping G and H.
Well, if you want to combine G and H, then
We're not doing that tonight, but
okay.
Whether we do or don't, explain to me why we need the first sentence in I, because I think the concept in I is buried in G and H and saying that you can't use 7922.000. You can't use the general balancing test. And that's what I read the first sentence in I to say.
I think it's just a recapitulation.
That's how I read it.
It's there, and I'm telling you again, it's there. You can't use this.
And you know why? Here's why. Because even we're saying not only can you not do it because it says it in the California Government Code, we're saying you can't do it because this ordinance says you can't do it.
No, it's different. State law, the old 6255, the new 7922.000 says that you can do it. This ordinance is saying you can't do it. And I think if we say once, maybe twice, but at least once you can't do it, I don't see why it makes any sense to say it 3 times.
No, but you can't assert the California Government Code as reason for doing this thing.
Right. Yeah, I is a positive, while G and H are a negative.
No, they're all negative.
No, they're right. I'm sorry. They're all negative, right? Neither the city.
They're all specifically contradicting, whatevering state law that says you can use a general balancing test. We're saying the law already says, and we're just clarifying how to say it. In San Francisco, you can't use the general balancing test because you screwed up and you abused it. The only basis that you can use for non-disclosure is a specific basis, not some general balancing test. I'm not changing my mind on that. What I'm saying is there are different ways to express that, and I'm not sure that saying it 2 or 3 times in ways that are slightly different helps. I think it actually confuses. I think saying it strongly once, maybe saying it again some other way, I'm just not with saying it 3 times in 3 different ways.
How about, just for kicks, I read F, G, H, and I based on the changes we've made. Take any final comments, and then I'd like to open this for public comment.
Before we do that,
Mhm.
on the rest of I,
Mhm.
regardless of whether the first sentence is there, how about that second sentence? It's something like any withholding, not all, but any withholding of a public record shall be based on an express provision. I'm not sure I would say of this ordinance because that's not necessarily the case. Shall be based on an express provision of law providing for withholding of the specific delete type of information, delete in question, or an express and specific exemption in state law that is not forbidden by this
So
ordinance.
not provided by the California Government Code?
Yeah, but some of it is also elsewhere in state law.
Okay.
Anyway, I'm trying to make that more readable because it's really wordy and a bit goofy. The concept is still good, but
Okay. I am going to read
Thank you.
F, G, H, and I. So F, budgets and other financial information. Budgets, including line item budgets, whether tentative, proposed, or adopted for the city or any of its departments, programs, projects, or other categories, and all bills, claims, invoices, vouchers, or other records of payment obligations or actual disbursements showing the amount paid, the payee, and the purpose of the payment, other than payments for services for which records are confidential by law, shall not be exempt from disclosure. Boy, that was a mouthful. Neither the city nor any office, employee, or agent thereof may assert California Government Code Section 7922.000 or any similar provision of law.
of state law.
Okay. Of state law as the basis for withholding any public record, period. H, neither the city nor any office, employee, or agent thereof may assert an exemption for withholding for any
Or withholding.
public record,
There you go.
any public records based on a, quote, deliberative process exemption, either as provided by California Government Code Section 7922.000 or any other provision of law that does not prohibit disclosure. I, neither the city nor any office, employee, or agent thereof may assert an exemption for withholding any public record based on a finding, or showing that the public interest in withholding the information outweighs the public interest in disclosure. Any withholding of a public record shall be based on an express provision of law providing for withholding of the specific information or on an express and specific exemption in state law that is not forbidden by this ordinance.
That's progress. Yeah.
Member Anderson, Member Wolf, anything else?
Hold on, I'm formulating something.
Oh, you're okay with this? Okay. Member Wolf is thinking.
I think you ought to say as much as you can. No, you can't accept. No, you can't accept.
Yeah.
Yeah.
Because what I've seen in the time I've been here is like exempt.
Mhm.
It's like, no, you think you can exempt?
Mhm.
No, you can't exempt. So I think the more times it's said, maybe it sinks in as we go along.
I'm thinking about that. Anyway, I think this is progress, and I still think that these concepts go 26 or 27, but I think we're making progress on the language. Very happy with that.
So I wanted to pick up on your thoughts about Chair LaHood on doing bullet.
Mm-hmm.
And so what I came up with, hold on, let me just copy this. Copy, paste. Okay, what I came up with was neither the city nor any office employee or agent thereof may assert California Government Code section, whatever it is, or any similar provision as the basis for withholding any public record requested, A, under this ordinance, B, based on a deliberative process exemption, or C, based on a finding or showing that the public interest in withholding the public record outweighs the public interest in disclosure, period. And then the rest of I in a separate paragraph.
What was the A there again?
A would be under this ordinance, or
Sorry,
B.
Okay, but wait, go back to before.
Before A?
Yeah, what's the
Neither
operating on?
neither the city nor any office employee or agent thereof
Right.
may assert California Government Code section, whatever it is, or
Right.
any similar provision as the basis for withholding any public record requested, A, under this ordinance, or B, based on a deliberative process exemption, or C, based on a finding or showing
Yeah.
the public
Okay.
interest.
I get B and C. I'm not understanding how A actually operates.
A is just what it says in G.
Well, all right. I don't want to belabor this, but that's
The ordinance itself has its own enhancements, its own provisions that are not in the CPRA. So G is just saying, contemplating my navel, this ordinance, you can't make a withholding. And then in H, it's expanding it to be based on a deliberative process, based on state law or any other provision.
okay. I hear you.
Beyond the ordinance.
Okay.
And
I guess I would.
I is just the gamut, broadly.
Okay. I guess I would just
Peeling it
push back slightly, and I will think about good ways to express it. That if elsewhere in the ordinance it already says you can't do this, you can't do that, you must do this, you must do that, I don't see why reiterating it in G is helpful. I think it's best to be as specific and direct in the original section, wherever it is, to do it there. Because I don't want people to point at G and say, well, this just has some catch-all that says you have to follow the ordinance. Well, obviously we have to follow the ordinance. Is there any specific that G, as Bruce has recrafted it, that G adds, or is it just reinforcing what's elsewhere? I don't really want to reinforce what's elsewhere. I want to say it right the first time and just say it once.
Well,
but again, let me think about how to do that.
These are umbrella clauses in a folding out of an onion. So G is within the ordinance itself. H is state law and thereof. And I is broadly.
I'm realizing too, we do need, if we were to leave these separately, if we were to keep these separate, G, we changed as the basis for withholding any, instead of documents or information, we had public record. We struck requested under this ordinance, but I think we might actually need to put it back.
And I would say no, because what this is saying is that what 6255, what the new 7922 that it says is that you can balance. And if on balance, the public interest in non-disclosure outweighs the public interest in disclosure, then you don't have to disclose. What this is saying is you can't assert that.
It's not her point.
We're under this ordinance.
Yeah, that's not her point. she's basically saying that the word requested, quote unquote, under this ordinance is meaningful because otherwise people may take it as only requested under the California Public Records Act.
Correct. And then we're saying the CPRA doesn't mean anything.
Then that's not what I'm saying. I think the only, all right,
So that
maybe I need to go to law school. The only basis that I understand that these code provisions come into play is in the context of a records request. It's not in the abstract. It's when presented with a records request, how can the city respond? And the answer is neither the city nor can do these things
but
as a basis for withholding a public record.
But 6721 doesn't exist anywhere except for this administrative code in San Francisco.
Right.
Right. So
And 67
G is applicable specifically to this sunshine ordinance. H, it talks about deliberative process, but it doesn't specify this ordinance. It's outside of this ordinance. And that's the distinction between G and H. There are some, it is somewhat of a bright line.
I mean, I wasn't prepared to argue this tonight, but there's a whole, there are many sections in CPRA that creates this overall statutory scheme of the burden on agencies to provide public records on request, with general rules, specific rules, exemptions, procedures, all of that. And so taken together, that's how I view state law. State law also provides that, local jurisdictions can provide faster, greater, better access. That's what we're doing here, but it's all in service of this concept of public records disclosure. It's not related to other things. So I think it's only understood to be in the context of public records disclosure.
So here's what I'd like to do. We've been talking about this for a while. I would love to invite some public comment on F, G, H, and I. And I know we have someone in the room who may want to offer public comment. Is there anyone online who may be interested?
There was no one online.
Okay, then I'd like to invite our guest in the room. And I think because we only have one person here, I don't even feel a need to put a strict limit, but I'd invite you to offer us your thoughts on what we've been discussing.
Well, it's late, so I'll try to keep my comments fairly terse.
Thank you.
Would you like to state your name for the record?
Yes, I'm Richard Nee. I served on the task force for 12 years from 2002 to 2014, and I remain sunshine active with several advocacy organizations. As I used to tell people back in the mid-1970s, my name is Richard and I am not a crook. Anyway.
You, I believe, that other guy.
I'm sorry. Thank you. Okay. Regarding subsection F, budgets and other financial information, I tend to lean toward Bruce's Member Wolf's point of view on this. And I would say after the first word, you could add in the language budgets, comma, at any and all levels of specificity. That's a suggestion. Moving down to GH and I, wherever it says withhold or withholding, I would insert the words withhold or redact, withholding or redacting. The reason I say that is an agency or a public official might give somebody a record with redactions and say, okay, I did not withhold the record. Here is the record. I gave it to him. And to me, that wouldn't satisfy. If I was a member of the public, to me, that might not satisfy. So I would say that, their use of 79.22 to redact, I would say should be proscribed. And I think that pretty much sums up what I have to say. Whether moving this to 67.26 or 27, I have no feeling either way. I'm comfortable either way. Whether you want to move it to one of those or leave it where it is under 24, I'm comfortable either way on that. In terms of combining any things like that, again, to me, that's neither here nor there. Although I would say that keeping the language in there about the balancing test, I would say keep it in there. As much specificity as we can put into this ordinance, I would say that's a good thing, regardless of whether it might be a bit more verbose, a bit more ponderous. But, we don't want to give any wiggle room here to people who might want to find ways to skirt or flout the ordinance. We want to be able to hold people's feet to the fire as much as we can. So I would say leave that language in there about the balancing test.
Thank you. Does anyone, since they're just the members and you here, do any members have questions for Mr. Nee?
On this stuff.
Okay, shall we proceed to the next item?
Yes.
Okay, or excuse me, next section.
Immediacy of.
Okay, moving on to section 6725, immediacy of response. And you may have noticed we had a note in here from Task Force Vice Chair Stein, who asked us to clarify what immediacy of response means and what an IDR applies to. This was when we reported back to the full task force about what we were doing and offered other members a chance to flag things that they think need some clarification. So how about this? I'm looking at how many subsections there are in this. There's A, B, C, and D. Why don't we give ourselves 5 minutes to read these subsections to ourselves and then come back with comments? Does that work?
What do you want to?
Okay.
Reasonable.
Hearing no objection, that's what we're going to do.
Holly?
Okay. I have a basic question. Instead of calling this section immediacy of response, can we just change the heading to immediate disclosure requests?
No, and here's why.
Okay.
Okay. Since you mentioned that there are 4 subsections, D is not particularly about IDRs, but it's on rolling basis stuff. So there's that. C, I think, could probably be moved elsewhere because it applies whether it's an IDR or a non-IDR. It's just sort of general purpose and is probably a 67.21 thing. And B is really related more to A and, sort of how you overcome an IDR if you can. Doesn't convert it from a non-IDR, whatever. It doesn't convert it, it's just how it's handled. So I think there's really, for me, kind of the A, B, and D, and it's about kind of, you could call it timeliness of response, immediacy. I'm not hung up on the heading right this second.
Okay.
But I think it's not just about IDRs is the point.
I agree with that, but I would see immediacy of response to being more of an action than a thing.
Well, immediacy is a noun. So if you want it to be more action, it should be like responding immediately, which I guess is a gerund.
Gerund. I haven't heard that word in a long time.
Gerund's a good one.
Well, I guess what I'm saying is it's kind of like the action of responding. This is the time frame of a response. That immediacy refers to a time frame versus reflecting on it on a record itself.
Mm-hmm.
Again, we could spend a lot of time on the headers. I'm not sure that we've settled on the header for 67.21. It seems like this is more about handling an expedited process compared to 67.21. Maybe if we just focus on the text tonight, and at some point we'll look at the headers and conform and yada yada on the headers.
Yeah.
Yeah.
Okay.
If we wanted to move immediacy, we could go expedited response.
Mm-hmm.
Right.
Or since we're talking about, it's all about the timeline,
Yeah.
right? Let's come back to this, but so renaming something like, allowed response times or permitted response times, or I don't know. I don't like any of those either, but
You're headed in the right direction.
okay. Without getting stuck on that,
On the text?
without getting stuck on the title, let's discuss the text.
Okay. So here's what I had to begin with. Line 1, notwithstanding the, I would say, 10 calendar day deadline
Mm-hmm.
for response to a request.
To a public records request?
No, for response to a request pursuant to California Government Code.
That can't be the right number.
No, I'm flagging all the numbers.
I'll tell you, 7922.535A,
Hold on, say that again.
7922.535A,
Little a?
yeah,
Okay.
in parentheses. And this.
And in this article or no?
Yeah, you can put as a placeholder and this article, lowercase a, capital III.
No, let's be, the article does not mean section.
No, it doesn't. Article 3.
Article
is-
3. Okay, just want to be clear.
Yeah.
Okay.
No, I've got a lot of Article 3 references.
Okay, great.
So this lowercase article, comma, Roman numeral 3, comma.
Right.
Okay.
Comma, a written request for information described. At some point, we'll have a discussion tonight or another time on whether it's information described in any category of non-exempt, public, we should say records, not information. Whether it's that category of thing or some other description, because this is what qualifies, right? But in any event, public records shall be satisfied no later than, this says the close of business. Let me make a quick argument now to move that to 4 p.m. rather than close of business. And if I can just explain why. There are instances where I have submitted an IDR and they said, yep, we'll have that ready by 5. I said, great, so I'll come down there. Yeah, we'll have it out there at 5, which means they have it out there at 5. They lock the door at 5. You can't find anybody at 5. And if you've got any question, you're stuck. And that happens to be a Friday. So, they've designed it in a way to.
I like 4 p.m.
There you go.
Okay.
Thank you.
Before we proceed,
Did you like that? Sorry.
I think we've got a cart before the horse situation.
Yeah.
Because we need to say that this subsection A is about immediate disclosure requests. Because right now we're saying notwithstanding the 10 calendar day deadline for response to a request pursuant to California Government Code and this article, a written request for information described in any category of non-exempt public records shall be satisfied no later than 4 p.m. on the day following the day of the request, period.
Right.
And if we haven't said,
No, hold on.
as applied to immediate disclosure requests, this sentence makes no sense.
I've got language to do that, but it's not perfect because it still buries the lead. And I know you.
Then we can't do that. I think we need a
we
heading.
we can make it better even if it's not perfect yet. So,
Okay, tell me what you propose and I will
Okay.
counter it.
So shall be satisfied no later than 4 p.m. on the insert business day.
The next business, the business day.
Shall be satisfied no later than 4 p.m. on the business day after.
Following.
I liked after better than following. All right, whatever. The day the request is received.
I think is made.
No,
Or was made.
no, is received. Because somebody's going to say, I sent it on that day, and the department's going to say, we didn't get it that day. It's when
Got
the
it.
department
Okay.
gets it.
Got
when
it.
it's
Right, if
received.
it's mailed. Yeah,
Right.
yeah.
Is received, and then you concatenate to the next sentence, if the words IDR, blah, 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 are placed, blah, blah, blah. So it strikes this deadline shall apply only. It's pulling those together. It's not, I agree, it's not the best crafted, but it's getting there.
Shouldn't that be the legal?
Yes, we have to lead with that. You can't end the sentence with that. It makes no sense this way.
This is one of the better written provisions. There's other
Yeah,
stuff
but
that's
it does
worse.
not make sense saying jump through all of these hoops.
If.
No, right. It doesn't make sense. It's too many words before you get to the point. If it was 5 words before you got to the point, I would be okay with that. It's too many words.
What is an IDR?
Yeah.
Yeah, we need to define an IDR before we say,
Yeah.
here's how you do all these things. Oh, by the way, this is what we're talking about.
Yeah.
Okay. Well, in essence, an IDR is any public records request that has the magic words immediate disclosure request across the top of the request and on the cover sheet, envelope, or subject line associated with the request, period. And therefore, the response to an IDR is faster because those magic words are included in a prominent location. But it's
That's not a definition.
right.
Okay, how about this? A request for public records that, and this is already passive.
On an expedited basis,
Yes.
something like that.
On an expedited basis. So can do we say members of the public may, I'd like to make it active, but perhaps that's not going to work. A request for public records on it may be made
To fulfill a simple, routine, or otherwise readily answerable request.
Can you say that to fulfill simple?
A simple, routine, or otherwise readily answerable request. And then period.
Yeah.
Next sentence, maximum deadlines provided in this article are appropriate for more extensive or demanding requests, but shall not be used to delay.
Okay, hang on one second.
Again, we're headed in the right direction.
How about this? Can we say a request for public records on an expedited basis may be made as an immediate disclosure request to fulfill a simple, routine, or otherwise readily answerable request.
Start out with immediate disclosure requests can be
Or
made.
public records on an expedited basis. Yeah.
Right.
Immediate. And am I going to capitalize immediate disclosure
Yes.
requests?
Yes.
Yes.
Those-
In quotes.
Yeah. Yep, I think this works. Request for public records on an immediate disclosure request for public records on an expedited basis may be made to fulfill a simple, routine, or otherwise readily answerable request, notwithstanding the 10 calendar day deadline for response to a request pursuant to California Government Code Section 7922.535A.
Wait. Slow down.
Okay.
They're really two, if you pull apart subsection A, I think there are really two sentences here. There's we've got the 10 calendar day deadline, blah, blah, blah. But notwithstanding that, there's this other thing, okay? Then the second sentence, which I think you're pushing up to the first, and that's okay. Something like a request for public, I'm thinking out loud. A request for public records shall be handled on an expedited basis if the words immediate disclosure request are placed blah, blah, blah. So make the first sentence.
Yeah.
Getting closer, you want it closer to the front. Okay. And then you take the first sentence, you flip that, and you make that the second sentence.
Give me 1 second.
Do some editing.
I mean, I'm almost of the mind with this to turn it into a bullet, kind of a procedure.
Well, we're getting there, but don't immediately go bullet on us.
Okay, hang on 1 second. I'm going to read this back to you.
I like bullets.
Don't be on the receiving end.
True.
Okay. A request for public records on an expedited basis may be made. Okay. A request for public records on an expedited basis. No, I should say a request for records may be.
Keep working
on it. A request for records on an expedited basis may be made to fulfill a simple, routine, or otherwise readily answerable request only if the words immediate disclosure request are placed across the top of the. Oh my gosh. We say request so many times it's killing me. Across the top of the request and on the envelope, subject line, or cover sheet in which the request is transmitted. notwithstanding the 10 calendar day deadline for response to a request pursuant to California Government Code Section 7922.535A, and in this Article 3, a written request for information described in any category of non-exempt public records shall be satisfied no later than 4 p.m. on the business day following the day.
That's where I said on the business day after the request is received. I think it works that way.
Okay. Okay. Yep.
Well, are you not leaving the door open for when they receive it then?
They receive it whenever they receive it, but they've got to respond by 4 p.m. on the following business day.
Right, but is after the same, could after be misinterpreted?
Why don't we tighten that up on the second pass?
Okay.
I think for the, I'm not trying to give them an extra day. If we can just go with this for the moment, because we're going to need to study how this language plays out.
Okay.
I'm thinking about they can say they didn't get it for a week.
That's true now.
And maybe they didn't.
Right.
Maybe they didn't.
So how do you tighten that up?
That's
You
a
can't.
different problem.
Can.
Okay.
If you send it to the wrong address, right?
Yeah.
Mhm. The next part that must be included is maximum deadlines provided in this article are appropriate for extensive or demanding requests, but should not be used to delay the response.
Yeah.
When you said shall be not be used to delay a response, did you want me to get rid of all those other words?
Yes, because you use them at the beginning.
Okay.
Yes,
Oh,
right. And you may want to say, not instead of maybe response, like something like completion of the disclosure or something like that.
Fulfilling a request?
Fulfilling the request.
Okay.
And actually, starting with maximum, that might lead into B, and maybe B starts with maximum.
Yeah, that's a good idea. That's fine.
Mhm.
Wait, so you want to move the maximum deadline sentence, or you want,
I want to move B
yeah,
to start at maximum. So
you want to move B? No. Okay. So the easier thing would be for me to move maximum down to B.
sure,
That's what
that
you're
works
asking.
too.
Okay.
Yeah.
Damn, they passed that budget.
Okay.
What if we move the Gulf of Mexico? Then is that?
I would like to do one last thing and tell me if you, hang on. Needed it. Okay. Can I reread A just because we've moved so much around?
Please do.
And then, okay, so right now I have for A request for public records on an expedited basis may be made to fulfill a, can we, instead of saying may be made to fulfill, may be made for a, for a simple, routine, or otherwise readily answerable request, only if the words immediate disclosure request. Can
You're
we?
right. There are too many requests
We
in
say
there.
a readily answerable query.
No, because then they're going to say
No.
it's a query.
No?
I mean, the
Start
word
with B.
request gets repeated so many times anyway. So
Yeah.
Start at the beginning.
All,
Oh.
or all ordinance.
Start again. We'll get there.
Can we say inquiry?
Start at
No.
the beginning.
Okay. A request for public records on an expedited basis may be made for a simple, routine, or otherwise readily answerable.
Or
Maybe.
move it at the
Oh.
beginning. A simple, routine, or otherwise readily answerable
Request for public records.
Public records request.
Okay. Yeah.
There you go.
Yeah. may be made on an expedited basis.
There you go.
Okay, hang on.
2 votes.
2 requests.
Hang on.
Member Wolf, are there other things happening in the world? Are we still part of NATO? Hard to say.
Remains to be seen.
Yeah.
Ukraine made a deal for minerals.
With whom?
U.S.
Okay, you all realize that this is not the task at hand.
You're editing.
Okay, a simple routine or otherwise readily answerable public records request may be made on an expedited basis.
Keep going.
No. The problem is it's not that we're expediting the request. We need to expedite the response. So a simple routine or otherwise readily
Just go with it for the
answerable
moment.
public records request may be made on an expedited basis only if the words immediate disclosure request are placed across the top of the request and on the envelope, subject line, or cover sheet in which it is transmitted.
I've got a way to shorten that too.
Mm-hmm.
Across the top of the request and on the insert cover sheet there,
Mm-hmm.
comma, envelope, or subject line associated with the request.
Associated with it.
Yeah.
Okay. See, I'm getting rid of transmitted.
Mm-hmm.
Transmitted's been dispensed with. Do we get a period at some point there?
Yeah, right there. Okay, but hold on.
It may not be perfect, but it's progress.
Can we say may seek an expedited response only if the words?
Try that.
Yeah.
We're not going to land on a final answer on this tonight. We're testing out concept.
Okay, a simple routine or otherwise readily answerable public records request may seek an requester.
No, it's the request.
May seek an expedited response only if the words immediate disclosure request are placed across the top of the request and on the cover sheet, envelope, or subject line associated with it. I think that works. Notwithstanding the 10 calendar day deadline for response to a request pursuant to California Government Code section blah, 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 and in Article
3.
And in this Article 3, a written immediate disclosure request for information described in any category of non-exempt public records shall be satisfied no later than 4 p.m. on the business day following the day the request is received. Period.
Yeah.
B, maximum deadlines provided in this article are appropriate.
Article insert 3.
Okay, 3, okay. Are appropriate for more extensive or demanding requests, but shall not be used to delay.
Hold on. Can we
Mhm.
drop be used to,
Mhm.
but shall
Shall
not
delay fulfilling a request. If the voluminous nature of the information requested, its location in a remote storage facility, or the need to consult with another.
Wait, sorry.
Yes.
Sorry. Shall not delay fulfilling what?
A request.
How about a records request?
Okay. If the voluminous nature of the information requested, its location in a remote storage facility, or the need to consult with another interested department warrants an extension of 10 days. What?
It's actually an extension of 14 calendar days. It was
Okay.
wrong in the law.
Okay.
Well, wait a minute. My read of it is that it's 10 days and they're able to get a 14-day extension.
Right. It's 10 days from an IDR.
It's 10 days for IDR.
Right. But okay, sorry. You have to read this with the code section that it's referring to,
Mm-hmm.
which may or may not have been the correct code section. but the correct code section is 7922.535B. So that's where a department can assert an extension, and the extension there is 14 calendar days. So what this is saying is even under an IDR, that you have 1 day under an IDR, but if it's voluminous or extensive, then the extension that you invoke under the state law is a 14 calendar day extent, or up to a 14 calendar day
Yeah,
extension.
I'd like to remove that completely.
What do you want to remove?
The whole state law provision.
Okay, so what's the concept that you would substitute?
10 days.
So it's 10
Period.
days, comma, the requester shall be notified.
So, okay, so then I don't want to argue about this, but tell me in practice, what's the difference between, I know the difference between 10 calendar days and 14 calendar days, but if it's 10 business days, what's the practical difference between 10 business days and 14 calendar days?
The reason why is because most respondents mistake the interpretation of this by saying that they have 10 days under the ordinance and then an additional 14 days under CPRA.
Right. And I'm saying that if it's a non-IDR, they've got 10 days and they can invoke an extension of 14 additional calendar days, period. If it's an IDR, they've got 1 day and they can invoke an extension of 14 calendar days. And the only basis that they can invoke that extension on an IDR is, as stated here, the voluminous nature, the location of remote storage facility, or the need to consult. It's not just because they don't feel like doing it.
6721 does not speak to 14 days.
No, but 25 does. 21 doesn't talk about timing.
Yes,
Can I make a recommendation? Why don't we, maximum deadlines provided in this Article 3 are appropriate for more extensive or demanding requests, which will not delay fulfilling a records request. If the voluminous nature of the information requested in an immediate disclosure request, its location in a remote storage facility, or the need to consult with another interested department warrants an extension of 10 days, the requester shall be notified as required by the close of business on the business day following the day the request was made, because this applies to IDRs.
Right.
It doesn't. Actually,
But it does, because required by the close of business day on the business day following the day the request was made. This is about IDRs.
Okay, but hold on. Unless 67.21
B says 10 days. They don't get 2 bites at the apple. They only get 1.
So let me understand. You're saying that you're proposing either a read or a write of this section that would not allow the city to ever invoke a 14-day extension under any basis?
Correct.
Well, they can, hold on. Somewhere it's got to be, because, well, you know what? Maybe this gets resolved on the rolling basis section.
No,
but
maybe
this
it doesn't. That's the difference.
But we're not there yet.
Right. So, okay.
The current.
Let's be real here, okay? If you make an IDR of the Public Utilities Commission and you say, I want to see some documents about pipelines on the peninsula, they will, I think, say, that's nice. We can't do that by tomorrow because that's complicated to go find stuff and it's in Millbrae and whatever and blah, blah, blah. So we need an extension. Bruce, you're saying that they may be able to get an extension, but of how many days? If it's an IDR?
10.
Calendar, business days.
Business.
Okay. So 10 business days or 14 calendar days, either way.
Hold on. I think we need to be consistent throughout. We either need to use business days or calendar
Okay,
days.
that's a
Because
different-
switching back and forth is
That's
really
a different
confusing.
question. I'm trying to play this out for 1 second.
Okay.
That's under an IDR. If they make a non-IDR request for the same stuff, and the department says remote storage facility, complicated, blah, 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 normally they would get 10 days under state law and under the ordinance. And Member Wolf, Bruce, you're saying that the city department would be able to invoke one extension for how long? Same? 10?
For an IDR?
No,
extensions.
no, for a non-IDR.
Oh, for non-IDR,
Yeah.
there is no extension for 6721.
There is in state law, and it doesn't say that you can't.
But the ordinance,
Use
the
that.
ordinance supersedes that.
Right, but right now under 25B, it doesn't make reference to that. It just says if the voluminous nature of the information requested, then you can take an extension.
I know.
And B is not connected to an IDR.
I am suggesting that extension be removed. Because you
What
can
happens when they
expand on
can't
it
do
with the
it?
rolling.
Right. So how reasonable is it if, let's say PUC actually wants to respond to your request, and it really is going to take them some time to find the thing,
Incremental rolling.
Okay, so as I said, we are going to address this in rolling, but I do have a question because if you look in A, we said notwithstanding the 10 calendar day deadline for response to request pursuant to California Government Code section, blah, blah, blah. And then in B, you want to say 10 business days. To me, it's very confusing going from A to B and switching from calendar days to business days. I think we need to pick a thing and stick with it.
Well, if you're going to say 10 calendar days, then it's 7 business days.
Well, okay.
10 calendar days is 7 business days. 5,
Correct. But
7.
The fundamental question here, if I may, is
Sorry.
whether or not you want to conform to state law or do something different. And the way that we've dealt with not conforming to state law is to provide for an IDR. That if it's an IDR, we have an expedited process. If it's not an IDR, then it's handled in the same time frames as state law. They can do it faster. They're encouraged to do it faster. We've got language about that, but they're not required to do it any faster than state law because, public records are public records. If you want it faster, you do an IDR. So tell me why you're suggesting that we somehow make it faster than state law for a non-IDR.
Well, there's no reference in 6721 to state law.
Don't worry about what's in there now. Talk concept. Why would you want them to move faster if it's a non-IDR?
Why would I want them to move faster if it's a non-IDR?
Yeah.
Now we're asking them to move faster if it is an IDR.
I know. That's why I'm saying I get an expedited schedule for an IDR. I don't get an expedited schedule for a non-IDR. If state law provides 10 days and 14 days for a non-IDR, why would you want a non-IDR in the city to be handled faster or sooner, knowing that we've got an IDR for something that's faster or sooner?
Because most times they will take the full period. And with an IDR, it demands that immediacy.
But if it's a somebody help me.
Okay, hold on. Let's, I think part of our problem is the whole calendar day, business day thing. Just to be clear, in A, we said 10 calendar days. And then Bruce, you said you don't mean 10 calendar days You mean 10 business days or the
No,
business
10
day equivalent of calendar days?
10 calendar days or 7 business days.
No, we're going to say one thing.
Well, what
So-
do you want to be consistent with?
Yeah.
Calendar or business?
I don't care as long as we're consistent.
Well, if we're going to be using business days, everything everywhere else, then
But we just picked calendar days in the section above. That's what I'm saying.
okay. So then stay with calendar days. Then 10
Okay.
calendar days.
Okay.
Sorry, can I just read the relevant portion of state law? It's only 2 sentences.
Sure.
And that might inform. This is 7922.535A. Each agency, upon a request for a copy of records, shall, within 10 days, and that's been interpreted to mean calendar days because it
Okay.
doesn't say business,
Okay.
right? Within 10 days from receipt of the request, determine whether the request, in whole or in part, seeks copies of disclosable public records in the possession of the agency and shall promptly notify the person making the request of the determination. The reasons, therefore, if the agency determines that the request seeks disclosable public records, the agency shall also state the estimated date and time when the records will be made available.
Right. The response is required.
Right.
Like you have to say what you have
Right.
within 10 days.
Not
don't have-
necessarily provide the actual.
Correct.
Right. So we tighten that up by saying you have to actually disclose. Okay, I'm good with that. I don't think that's
Well, you could do one of two things. You can, the way I've always interpreted it was like what you just said, Chair Lewid. The
Mhm.
response doesn't mean you have to disclose it. You just need to respond as to when the records will be made available. For us with the IDR, it's just currently by the end of the following business day. If they have the records, great, and they can provide it, great. But if they don't have the records, they have to at least say, we have the records, and we'll provide them to you within 10 calendar days from now.
I could probably live with that. Let me read B for a second.
Okay.
So 535B, in unusual circumstances, the time limit prescribed may be extended by written notice from the head of the agency or a designee to the person making the request, setting forth the reasons for the extension and the date on which a determination is expected to be dispatched. No notice shall specify a date that would result in an extension for more than 14 days.
Two bites of the apple.
Right. That's the 10 days and 14 days. And then it defines unusual circumstances to be essentially the field facilities, voluminous nature, constructing a whatever, or,
I'm saying do not allow the 14-day part. The expediency is 10 days. You have 1 day to respond, and then you have 10 days to fulfill.
Okay, and I think I may be able to live with that for an IDR.
Yes.
But not for a regular request. I tend to think at this point, unless I'm persuaded otherwise, that a regular request should follow the state law deadlines, and only an IDR should have an expedited deadline, and only if it's, as we described it, a simple, routine, or otherwise readily answerable request. If they say, I want, 1,000 different documents from 1952 and I want them by tomorrow, they're not going to get that by tomorrow. They may get a request by tomorrow. And I'm not even sure they're going to get 1,000 records from 1952 in 10 days. And so let's not create the expectation that that's going to happen. That's just not realistic. If it's a regular request, if that's what they would have to do under state law, or invoke some other thing and, rule of reason and drip.
You want to give them more time than what we've
I want to give them enough time to answer the request. If they can do it quickly, if it's something that's sitting on their desk, make a copy, email it, get it out the door. If it's something that's going to take a while, give them the time to do that.
Well, here in 6721C, it describes. It says whether or not the contents of those records are exempt from disclosure, and shall, when requested to do so, provide in writing within 7 days.
Yes.
Actually,
Following
we
the
changed it
receipt.
to 5 business days. So I think we should change it back to
Change it.
7 calendar
You
days.
can do that. But that's an EFNQ request. That's a special thing under Sunshine. That's
What's
not
EFNQ?
existence, form, nature, and quantity.
Oh, okay.
That should be only a week. That's 5 business days or 7
Yeah,
calendar
but
days.
that
fine.
is what the IDR response by the end of the next business day is. It's an EFN.
No.
Yeah.
An EFNQ should not result in providing any records. It just provides an inventory.
Right.
An IDR actually provides records that are, as we said, simple, routine, or otherwise readily answerable.
Okay. Fair enough.
I'm not sure that we're actually in disagreement at the end of the day here.
No.
Okay. Getting back to where we were. Okay. I think one of the challenging things too is the difference between, we sometimes use respond to mean respond to a query but sometimes we use respond when we actually mean fulfill.
Right. We've used words like respond, fulfill, satisfy, provide.
Right.
And they mean different things in different contexts.
Right.
It's an acknowledgement.
That's a different thing.
When we want to say response, we want an acknowledgement that something exists or doesn't exist, but acknowledgement of the request.
Okay. So so B currently says maximum deadlines provided in this Article 3 are appropriate for more extensive or demanding requests, but shall not delay fulfilling a records request. If the voluminous nature of the information requested in an immediate disclosure request, its location in a remote storage facility, or the need to consult with another interested department warrants an extension of 10 calendar days, the requester shall be notified as required by the close of business on the business day following the day the request was made.
Sure.
I think so.
Okay.
So let's be clear. This means that only for an IDR that you get 1 plus 10.
Right.
Okay.
Mm-hmm.
But for a regular request, that's a 21 request, that you potentially get 10 plus 14.
I don't agree with that.
Come on.
No, because the way we've been operating all these years is that 14-day extension does not exist.
No, I don't think we've said that.
That's the way it reads. There's no such thing as 14 days in 6721.
But boy, is everyone confused because they keep bringing it up. Everybody thinks it's 10 plus 14.
I know, but they're wrong.
Yeah, I know. So we got to be explicit here.
That's right.
Okay.
Has the city attorney given us any opinions on that?
No.
Not specifically.
Then why don't we ask?
We may not want to know the answer.
Right.
So, Member Wolf, just talk to me for a second.
Yeah.
If we do 1 plus 10 for an IDR, right? And make very clear that if you want something, on an expedited basis, that you go IDR 1 plus 10, why can't you live with 10 plus 14 for a non-IDR if that's the standard under state law that applies to everybody else?
Because it'll be abused.
I don't think it's being abused now.
It is.
Well, of course it is.
How many timeliness determinations do we make on a regular basis?
If they miss it, they miss it, but that's the deadline. And we can have other language in here as well. We should in D about rolling basis, that if if somebody's asking for 25 things and you find the first 5, then you turn over the first 5 as soon as they're available, and the rest of the 20 as they become available. There's no reason, and they should not wait until the last day. And I don't care if they put it in writing. I want to fix D. I'm totally
Okay, how about let's do C. C might be easier. I have the one thing that jumps out is take out his or her and just replace that with a reason. The person seeking the information need not state a reason for making the request.
Yeah, all of that's true, but I think again I said that I would move that to 21 because I think the C paragraph applies whether it's an IDR or a non-IDR. I think this is about not
This is true, and
seeking reason.
is that not stated elsewhere?
It either is or I've got it captured elsewhere. Sorry.
How about this? Why don't we edit this internally to fix the language, and then I'll put a note on it that says, where do you want to move this?
There you go.
No, where do you want to move this?
Oh,
6721.
I think
Okay.
21 somewhere. Yeah.
Okay. But
Maybe.
since we're not going to move it today, let's make internal edits.
Okay. There are actually there are 2 sections to it. Hold on a second. If you look at current C, the first section, the first sentence is one thing. It's the no stating of reason. Okay.
You're right. The second thing, where a record being requested contains information,
Right.
instead of most of which is exempt, we say that is mostly exempt from disclosure.
Yeah, that's fine.
Yeah, that still would work in 6721.
Right.
Yeah.
But the second sentence, I think, also either goes to 21 or again, it goes to 26 and 27 because it's dealing with
Redactions.
redaction
Okay.
and alternatives. It goes to the concept of minimize non-disclosure, minimize redactions, suggest alternatives, get them the stuff.
How about this? Move first sentence to 6721 and the rest to 6727. Yes?
Yeah, something like that.
Okay.
Yeah. And we can edit that second sentence. I think you were on the right track to cut some
So
words.
where a record being requested contains information that is mostly exempt from disclosure under the California,
No.
under under what?
It's better in 6726.
Yeah, 26 or 27, and those could get merged later. Where a record, I would drop being, where a record requested,
Okay, where a record requested contains information that is mostly exempt from disclosure,
comma, strike the rest
Okay.
of that.
the
From
city.
disclosure, comma,
Okay.
the,
Do you need the however?
no,
Okay.
see, this is where I
Right,
go to the
okay.
department, but if you want to go the city or
Oh, the
the respondent,
Responsive, yeah.
whatever, the responding department,
sure, the responding department or custodian.
fine for the moment. That's a placeholder, but yes.
Okay.
Well,
I don't want to give that. I am not interested in giving this to the city attorney. The point is, it's the department that decides what to discose. And
Responding department or
that's not.
custodian.
This is not about what to disclose. This is basically saying where whatever is already considered to be exempt,
right.
that they have to help the
Yeah.
requester where
So-
they can find it somewhere else.
Right. So this is actually where I would be even stronger in saying the department shall inform the requester, that it's a department responsibility obligation to help.
Yeah, but exemptions are
who?
based upon a legality of law. It's based on a legal basis.
Okay, how about this?
Before this comma and
But
after.
a custodian won't know.
Okay, why don't we say the city attorney, responding department, or custodian of the record shall reform the requester of the nature and extent.
No, this is not a city attorney function. This is a responding department function.
No, I disagree.
So
The department will only know what to exempt after
No.
consulted with the city attorney.
No. Let's read it back. Where a record requested contains information
That is mostly
exempt from disclosure, right?
Who makes that determination?
The department determined that with city attorney advice.
We know that they don't make it. They don't have enough knowledge of the law to do that.
I don't care. It's on them to decide. Under state law, period. Whoever decides. The point is somebody needs to inform the requester.
Member Wolf, I think Member Pilpel is essentially saying the point person is responsible for telling the person who requested. So they, if they've requested it from DPW and DPW goes and talks to the city attorney and says, what's exempt, and they say, okay, this is exempt. It's not the petitioner's responsibility to go chase down the city attorney and figure out which person in that office to talk to. It's the person in DPW who goes back to them and says, the city attorney told us this.
But this is not saying that the petitioner would go chase down the city attorney. This is just saying the city attorney will provide additional information to the requester.
Right, but
they
it's not up
won't.
to the city attorney.
They'll provide it to the person in the department who's responding to the request.
It could be as vague as saying the requester shall be informed, but I'm trying to avoid that language and say who does stuff. And if the answer is that this one's on the department, that's why I'm saying the department shall inform.
I get what you get. I get what you're saying in concept, but that's not the reality. The reality is the city attorney is going to make the decision. And many of these respondents won't ask.
They don't
They'll just say, it's just like when we say, well, what was the nature of the exempt information that causes it to be exempt? Okay. And then they don't say. They just say it's exempt. I can't tell you why.
Okay. This is not talking about what's exempt or why. This is saying if you ask MTA for some stuff, and their response is most of this is exempt from disclosure, then it's on Caroline Celaya or somebody else over there to say, okay, I see what you're looking for is blah, blah, blah. Here are some other ways that you can find it. I think I understand what you're looking for. Let me help you figure that out. Because that's my obligation, is to help you figure it out and get as much of what I can get you that is subject to disclosure. That's on the department, not the city attorney.
All right, I have a different view of it.
Get past the who decided that it was exempt. I'm already past that. That's a different question. I'm just trying to help the person get as much of their stuff as we can get them.
I don't believe that the custodians have enough information or knowledge to be able to give accurate answers.
I'd like to hear what Member Anderson thinks.
Oh, gee, thanks. I think the custodians of records know more than you may give them credit for. That's right. And I think that if they've been doing this particular function for a while, they may have places they can steer a requester to where they can get the information, or they may say, let me make a call to see who you can talk to. So yes, they can help steer. I'm not saying all, but I'm saying that most all will try to help.
And even if they don't have the answer, they are still the point person.
Yeah.
Right. I mean, we heard earlier tonight, Vivian Poe may not be the expert in HR, but we tasked her to go find the HR person and figure out the Jim Ricasio thing. That's what they're supposed to do, is to figure it out. David Steinberg isn't the expert on trees, but he'll find somebody in urban forestry to answer a tree question. Laura Lynch at PUC, same thing. They have point people in the various divisions and bureaus. Jen Court's not an expert on every single area of law, but she's got 200 attorneys that'll answer to her. That's how it works. That's the practice.
May I read back the edits of what we have so far?
Please do.
Okay. So we're saying move this first sentence to 6721. The person seeking the information need not state a reason for making the request or the use to which the information will be put, and requesters shall not be routinely asked to make such a disclosure. Then this other part, which we're planning to move to 6727, where a record requested contains information that is mostly exempt from disclosure, the responding department or custodian of the record shall inform the requester of the nature and extent of the non-exempt information and inquire as to the requester's purpose for seeking it in order to suggest alternative sources for the information. It says which that may, I'm going to change it to that may involve less redaction or to otherwise prepare a response to the request. The only thing that jumps out at me is that we say in the first sentence, shall not be routinely asked to make such a disclosure. And then in the second part, which we are separating from it, we're saying, and you're going to be asked why you need it.
So then maybe they do stay together and they both end up in 21 somewhere.
Yeah, and the request for why you need it is in response to the fact that
Right.
most of the, or part of the information is redacted. So
And
depending on exactly what it is you want to get to, you know, what your goal is, what the goal of the requester is, the department may be able to say, oh, if you're looking, if
Right.
that's where you're trying to get to, then I would say go over here, because you may be able to find the information there.
Can I ask you what you're trying to get at? And if they say, I'll tell you, great. And if they say, no, I don't want to tell you, I've already said that, okay, fine.
Here's the thought. We changed the first may to shall, where we say shall inform the requester of the nature and extent of the non-exempt information. I mean, I want to say and may inquire.
Yes.
As to
yes,
the-
that's
okay.
fine.
Fine.
Yeah.
So it's not that,
Yes. in
yeah,
fact,
I
got that.
think that's better. Okay, may inquire as to the requester's purpose for seeking it in, and I'm going to take out the comma, in order to suggest alternative sources for the information that may involve less redaction or to otherwise prepare a response to the request.
Right. Shall inform, may inquire. Yes. Some of this, I think, is restating elements of state law, but I think it's making it very clear to both parties who does what. And I'm trying to have that be less obscure and more requesters shall or may, departments shall or may, and city attorney only advises. I want to cut out city attorney unless they really are germane.
Are we ready to move to D?
I just want to, I'm not gonna refer to the city attorney part anymore.
Okay.
When we talk about fulfilling the request,
Mm-hmm.
we can also use language like shall be satisfied.
Mm-hmm.
You know, I think that might be, you know, just as if you want to use other words and constant repetition of fulfillment.
Yeah. Is there a spot in A, B, or C where you were thinking of doing that, or just keep that in our minds for when
I
it
would
comes?
just say keep it in your minds. It's just a passage that I think sounds good. Also, it has just as much force of you know, to compel as fulfilling.
I want to pick up on that for a second. Can we put in a note somewhere certain words that we want to either intentionally use interchangeably or not, and maybe define, because we've talked about all that.
Yeah, I'm going to put that right at the top of the document, and
I don't have an answer on this, but I want to.
okay. Preferred language substitutions. And Bruce, you said, okay, so we were talking about fulfill as a substitute for,
These are all concepts.
okay,
Fulfill.
No, it would be shall be satisfied.
okay.
Satisfy.
Oh, for respond, okay, respond,
fulfill, satisfy, answer, inform,
Deliver.
Okay.
Yeah.
Answer, inform, deliver. Anything else?
If you think of others, feel free to put them in that category, because that's where we're going with.
Yeah.
If we want them all to be the same, then let's just pick one and do it throughout.
No, we want variety. Otherwise, it's harder to.
Well, no.
Good language.
Hold on.
Yeah.
If we want the same if we want the same result, then I think we pick a word and use it throughout. If we want different responses, let's understand that there are different intentions. If you respond to a request by the following day, that doesn't mean that you're necessarily providing the record.
Okay. And actually, here's an interesting thing. I feel like respond and answer sort of are closer together, where it's like it could be, where you're responding to or you're answering the initial.
Sure.
And you're going to get another one in D.
But fulfill and satisfy are different.
Yeah. Okay. You're telling me what's going to show up in D. Okay, I'm scrolling back down. But that is, okay. I'm glad we broke that out. And if you think of other words that we might use, I'll put them up there. Okay.
Back to D.
Back to D. Okay, I'm ready.
Okay. All right. So on language there, notwithstanding any provisions of, I would just say state law.
Mm-hmm.
Okay.
And I would probably strike or this ordinance unless there's a good reason to keep it in. Anyway.
We've been consistent by leaving it in.
Let's leave it in.
For the moment. Okay. In response to any regret of non-exempt public records, not information, when so requested. Maybe we drop when so requested. That's the thing.
Mm-hmm.
That it's not when so requested. It's just standard operating procedure.
And in response to request.
Right.
Yeah.
That the department or the city, whatever.
It should always be as soon as possible.
Right. Yeah. Right. How about that?
Yeah.
The department or the city shall produce, blah, blah, blah.
There you go. Shall produce. Add that to your list.
Oh, hold on. Oh, hang on. Okay. Shall produce. Okay.
Just produce. Because we're not doing may versus shall.
Oh, okay. 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 You're right. Okay. Going back to now, you were saying instead of city or county, you're saying
the department. I'm still stuck on department, but whatever.
The department or custodian?
Yeah, you can go with that for the moment. That's fine.
Well, is there a distinction between city and county?
No.
No.
It's the city and county of San Francisco. That's what it's referring to. But the point is, the city doesn't specify who the actor is. It's just saying writ large. Okay, we'll come back to that. The department or custodian, I can live with that for the moment. Shall produce any and all. Right. As soon as reasonably possible on an incremental or
department
basis.
or custodian of records. Or
yeah, it's fine. We'll fix that in the future round. Rolling basis such that responsive records produced as soon as possible. By the end, by the end of the business day that they. Could we just say are produced as soon as possible, period? How is by the end of the same business day that they are reviewed and collected? What if you review? First, you have to collect them, then you have to review them, and as soon as they're collected and reviewed, they should be produced.
Yeah, but we're talking about it being a one-day turnaround.
No, we're saying as soon as possible.
No, it's saying the same it says as soon as possible with a deadline.
So now we're back to 5 p.m. So if you finish reviewing records at 4:30, then sure, you should send them out by 5 p.m.
Well, say 4 p.m. Go back to add in the 4 p.m.
Right. So if they're done at 4 p.m., then send it out at 4 p.m. I don't want people to sit on stuff. So just say as soon as possible, period.
Yeah, but then that means there's no deadline. As soon as possible can be 3 days. That's as soon as possible.
Okay.
As soon as possible, comma, ideally by the end of the same business day that they are reviewed and collected.
Ideally, I don't think ideally helps.
Okay.
How about as soon as possible after they are collected and reviewed, period?
That's an open door.
If they can say, you know, we got it out 20 minutes after we were done, that was as fast as we could.
How about this? As soon as possible on the day they are collected and reviewed.
But that they may not be within the first day after they receive the request.
No, but that's separate. That doesn't have anything
Right.
to do with this. This is
saying
about
you
rolling
can't-
basis.
Right. This is saying you can't sit on stuff.
Right. So if you can't provide it within the first day after receiving the request, then you can provide it on an incremental or rolling basis.
No, you can, you shall.
Okay, you
Right.
shall.
So notwithstanding any provisions of state law or this ordinance, in response to a request for information describing any category of non-exempt public records, the department or custodian of records shall produce any and all responsive, do we have to say public records or just responsive records?
Stay with public records.
Responsive public records as soon as reasonably possible or on an incremental or rolling basis, such that responsive records are produced,
Or provided.
are distributed,
I want
provided.
to give an
This is
example.
where we're stuck on words.
I want to give an example. I have a person they're in the middle of a lawsuit or a court case, and they need documents for discovery from the city. Okay, they do an IDR, and they need them as soon as possible. Okay, so now the city says they respond by 4 p.m. the following day by saying, we have these documents, there are 50 of them, but we still have to review them. The rolling and incremental basis is as soon as we finish with page 1, we'll send that to you. When we finish page 2, we'll send that to you. When we finish with pages 3 and 4 and 5, we'll send them to you. That's rolling incremental. That's what this means.
Right.
It
may
doesn't
not-
mean
it
it
may
doesn't
not be
mean we
reasonable.
read all 50 and then send you 50.
No, but it may not be reasonable to do it page by page. It may be document by document, but that's on a case by case basis. The point is that you can't sit on the first 50 documents until you get to the 51st, and then you send a whole package. I don't think we're going to parse this to the nth degree. I think if we convey that it's an incremental or rolling basis, and as soon as if you've collected all the documents, as soon as you've reviewed them, if you're ready to produce or provide, that you do that.
But
And
the
you don't
next
wait.
sentence, wait a second, David. The next sentence is
Says that.
exactly what we're trying to prevent.
Right.
What?
I think it's pretty clear.
Yeah.
We don't want them to hold the whole thing
Right.
until they've all been reviewed and collected. We want them to review, if
Why
there
does
are
it say
50
reviewed
pages,
and-
we want them to review 5, send the 5.
Okay, why do they keep saying reviewed and collected? It should be collected and
It
reviewed.
should be collected and reviewed because it's in the wrong order.
Okay, how about this? Okay, so far, based on what you all have been saying, I have, notwithstanding any provisions of state law or this ordinance, in response to a request for information describing any category of non-exempt public records, the the department or custodian of records shall produce any and all responsive public records as soon as reasonably possible or on an incremental or rolling basis, such that responsive records are provided as they are collected and reviewed. This section is intended to prohibit the withholding of public records that are responsive to a records request until all potentially responsive documents have been collected and reviewed. Failure to comply with this provision is a violation of this article.
I would drop the failure sentence because I think any failure throughout the ordinance.
That's actually true.
Yeah, I think those are all silly. And the previous sentence where it says this section is intended.
This section prohibits.
No.
Okay.
I would just put a blank under that after section, because I think we're going to need to include the section number. Their current convention is where they say this section, it would say this section 67.25 or 25B or whatever.
I'll put TKs,
Yeah.
which is.
Okay. Yeah, TK. Oh, yeah, you would be.
Yeah.
That's an old Bay Guardian.
You don't think somebody will say, if you remove the very last sentence, and if this gets amended without it, that say, well, in the previous version it said failure, but this one doesn't say failure.
I will include in my notes, because I was doing a version that's got extensive footnotes on everything, and this will be a global fix, that wherever it says that, it's not intended to be read in any other way, just that requirements throughout the ordinance are to be implemented. Failure to do so is a violation of the ordinance.
And can we, right now we say this section, TK, we say is intended to prohibit. Why don't we just say this section prohibits the withholding of public records that are responsive to a records request? Oh, no, actually.
Let me think about that, because there's some other places where it's about intended or construed, right?
Mm-hmm.
That provides some guidance on legislative construction. That's another thing you can put somewhere else is intend versus construe. But I'm telling you, there's a lot of global
That's just coming at it from
here.
opposite directions. Intent is I intend and you construe. So it's
Correct.
looking at the thing from two different directions.
Right. Yep. I mean, there's somewhere in here where it says this provision shall not be read to mean that blah, blah.
And that's way too many words.
Right. But it's all the same
Concept.
yeah.
So what did we decide about failure to comply? We're striking it or not striking it?
I would strike it and just say globally, we will make clear failure to comply with the ordinance is failure to comply with the ordinance.
Yeah, we'll put that in somewhere. Yeah.
Okay. Maybe that goes up high?
Yeah.
Okay.
My way of dealing with that, we'll talk about it at some point with complaints, that we've got to talk more broadly about powers and duties and whether it's just Article 3, Article 2, other failures, penalties. That's a long, huge discussion. I don't, the point is, I don't want to say that failure to comply with this provision is any better or worse than failure to comply with any other provision.
Yeah.
If you're not doing it, you're not doing it. And by the way, stop doing that.
Okay. That takes us to,
Public comment.
yeah. Okay, so we have, what I'd like to do is, just because we did 4 of these, I'm going to read our current edits on section 6725 A, B, C, and D, and then invite public comment. So, section 6725A. A simple, routine, or otherwise readily answerable public records request may seek an expedited response only if the words immediate disclosure request are placed across the top of the request and on the cover sheet, envelope, or subject line associated with it. Notwithstanding the 10 calendar day deadline for response to a request pursuant to California Government Code section number, and in this article 3, A written immediate disclosure request for information described in any category of non-exempt public records shall be satisfied no later than 4 p.m. on the business day following the day the request is received. B, maximum deadlines provided in this Article 3 are appropriate for more extensive or demanding requests, but shall not delay fulfilling a records request. If the voluminous nature of the information requested in an immediate disclosure request, its location in a remote storage facility, or the need to consult with another interested department warrants an extension of 10 calendar days, the requester shall be notified as required by the close of business on the business day following the day the request was made. C, and this might be moved to section 6721. The person seeking the information need not state a reason for making the request or the use to which the information will be put, and requesters shall not be routinely asked to make such a disclosure. When a record requested contains information that is mostly exempt from disclosure, the responding department or custodian of the record shall inform the requester of the nature and extent of the non-exempt information and may inquire as to the requester's purpose for seeking it in order to suggest alternative sources for the information that may involve less redaction or to otherwise prepare a response to the request. D, notwithstanding any provisions of state law or this ordinance, in response to a request for information describing any category of non-exempt public records, the department or custodian of records shall produce any and all responsive records as soon as reasonably possible on an incremental or rolling basis, such that responsive records are provided as they are collected and reviewed. This section, TK, is intended to prohibit the withholding of public records that are responsive to a records request until all potentially responsive documents have been collected and reviewed. Period. I'd like to invite public comment.
Good evening. I'm still Richard Nee. Starting with the new B.
Mm-hmm.
Where are we? Okay. Maximum deadlines, I would replace the word maximum with extended. A deadline and maximum are redundant.
Mm-hmm.
Deadline defines a maximum time window, so I would say extended deadline.
Mm-hmm.
I agree with moving C to section 67.21. And at the end of D, this section is intended to prohibit the withholding. I thought that was changed, and this is a question I thought it was being changed to this section prohibits the withholding of public records. I thought that was suggested, but you know.
We went back and forth.
Mm-hmm.
Okay. That's pretty much it.
Okay.
May I? Oh, go ahead.
Let's let Member Anderson, who has not gotten in as many words.
I don't have.
Oh, I thought you were turning to say something.
No.
Okay.
I need to run for nature call. I'll be right back.
Okay, Member Pilpel, go ahead.
I think I did have a tweak based on what Rick just said. The section TK is intended to prohibit I think withholding is the wrong word. I think it's prohibit delaying disclosure of records that are responsive. It's not that they're withholding.
Mm.
See, we've got this concept of withholding.
Mm-hmm.
Withholding is that you're not providing.
Mm-hmm.
This is more the concept of delaying. So
Yeah.
it's to prohibit
We don't need to see the delaying, prohibit delaying disclosure of.
Right.
Yeah.
Yeah. Does that, you caught, yeah, you helped me with that.
Yeah, I like that. And then I am highlighting is intended to prohibit with perhaps change to prohibits,
Right.
which I like better because it's fewer words.
So you're saying this section is intended to prohibit the delay?
This section is intended to prohibit delaying disclosure of public records that are responsive. So to prohibit. Yes, thank you.
That's right.
Delaying the release of public records that are responsive to a records request until all potentially responsive documents have been collected and reviewed.
Or maybe then again, potentially responsive.
Oh.
Maybe it's records and not documents.
Yeah, yeah. And do we need potentially? Oh, but I guess they're potentially until they've been
Collected
reviewed.
and reviewed.
Yeah.
Again, this is not going to be perfect, but this is improving the language.
Okay, so here's the question. And I don't know if Member Wolf is back. It is 9:05. The next two sections are rather short. However, we often have many things to say. Do you want to do one or two more, or would you like to call it a night?
I'd go for call.
Okay.
I would split the difference. I would say if we can take a couple of minutes to not go over the text, but to talk about concepts for a second, because I think they are pretty related, and that may jog our discussion next time, particularly if we're going to go another 2 months.
When you say concepts, you don't mean specifically concepts in 6726, but broad concepts.
No, I mean the concepts in 26 and 27 that I just think withholding, justification, minimizing. I just wanted to talk about that for a moment. And then if we're going to go 2 months without, then we can let that percolate for a bit. And we will start with, I agree that we should start with these two next time.
Okay.
What's the plan?
Member Wolf, we think we're not going to continue on to the next section. However, Member Pilpel requests that we discuss the concepts briefly of withholding and justification of withholding, because I think he has some ideas he wants to share.
Okay.
And then we could get some public comment on those concepts without actually doing the line editing.
Okay.
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 So you had some thoughts you want to share?
Yeah. I mean, I think both concepts are important. As the current headers say, withholding should be kept to a minimum, and withholding should be justified, right? I don't think that they're working against each other. I think that you take them together and you say, yes, in fact, we should disclose as much as possible. Where we're not disclosing, where, the city is not disclosing, it should be for a good reason, and it should be explained. And one shouldn't have to come back several times and say, oh, well, you withheld information or you redacted, but there was no citation for why. No, that's the standard, right? So I think merging these two sections, taking things like we flagged today from sub C, 25C that could be moved to 21. If we can put everything in this new section that covers withholding and justification, therefore, I think we'd be in a better place.
Okay, I understand what you're saying about merging the two, and then what did you want to move from a different section into here?
Possibly the 24 GHI stuff that we talked about earlier.
Okay, I see what you're saying. Member Wolf?
Just trying to read some notes that I've written some time ago about these two sections.
And then while you're looking, one other thing at the end of 26, there's a reference to fees, that you can't charge a fee, blah, blah, blah. So I think I took a small snippet of that sentence and moved it to 28. and just said that you can't charge a fee. I was trying to put all the fee stuff in 28.
Yeah, on fees.
I didn't want to talk about fees tonight, just saying that,
okay.
that all lands there. So again, I don't want to go into great detail. If you look at the current 27D,
Yeah.
27D is remarkably similar to 25C. So that's an example of stuff being in here twice that drives me crazy. Let's say it once, let's say it strongly, let's say it in the right place, and let's not say it twice, because then someone will say, well, it said one way here and a different way there.
Yeah, or the context. They may
Right.
take it as contextually being different.
Right. Unless there's a good reason to do it. If it, what are we saying there? And again, either that lands in 21 somewhere or it stays here, but it just doesn't. I'm doing a thing with my hands.
You said 6725C is where it's what it's similar to.
The second sentence, yes.
Yeah. Okay. Okay. So, okay, those are some thoughts. Member Wolf, any response or thoughts, general thoughts on the sections we're going to head into next time?
Let's see here. Where's that again? Oh, here. Actually, I had some notes with regards to GH and I of 6724 that I missed mentioning before, but actually moving that whole section into a new paragraph, into a new section in between 6726 and 27.
Ah, okay.
But it could also land in 26, 27, or emerged, whatever.
Yeah.
I don't think anyone's talking about losing the language.
Yeah.
It's just
No, right. This is just a little reorganization.
Yeah.
Let me see what I have here. 67, prohibited basis for withholding. Oh no, justification for withholding. Any withholding or justify a statement of withholding. So I guess the one thing that might be missing from something like 6727 in general is that it says any withholding of information shall be justified in writing as possible. That, maybe just to say a statement of withholding. I don't know. I have to reread my notes here. General description.
Can we get into more of that next time?
Yeah, we can.
Okay.
I need to collect my thoughts on what I had here.
The key thing I wanted to say here is I think the language at the beginning of 26 is good and strong, and that's where I would start this whole area. You cannot withhold a record in its entirety unless literally everything is exempt, which is pretty unlikely, right? So you're really mostly looking at redaction with, keyed references, and where you're withholding, you've got to justify that, and you can't just make it up on the fly.
Right.
So, the more, and I think we can say that with fewer words so that they're not like, oh, we found some brand new concept that we pulled out of whatever.
Right.
No,
right.
you just, yeah.
So on that note, and just to keep our wrapping things up going forward, I'd like to make one last call for public comment on things we've just discussed, which were more sort of conceptual things that we'll discuss regarding withholding and justification of withholding next time. But would we like, and it looks like there's no interest in making final public comment on this. So Ms. Peterson, if you could make note that next time we will pick up with section 6726.
I'm sorry, 2 other related things.
Okay.
Yes, that's the correct note.
Okay.
Uh,
I will also note that Member Pilpel, based on my request at our last meeting, had drafted a memo that I'm going to look at. We talked about reaching out to, and Ms. Peterson, he's going to give you a copy that let's not put, I'm thinking about this. We could attach this to the file for the next meeting, but I am likely to make some edits on before I send anything out. But the idea is we want to reach out to departments to seek their input on anything that any problem spots that they've run into in the ordinance where they are seeking additional clarity to make sure that we're addressing those questions.
So in handling the document.
I'd be very specific in that verbiage. That you're,
Member Wolf.
I'd be very specific as to what you're asking for. Otherwise, you're going to get a whole lot of repeal this, repeal that.
It could be interesting to hear what they have to say.
Yeah, I don't know. I feel like it's poking the bear.
We're getting some laughing from the gallery.
It's like poking the bear.
if I may.
Yeah.
Member Pilpel.
Okay. So following on the discussion last time, I, drafted this. I would very much leave it to Chair LaHood to tweak it and send it as she sees fit. I was not intending to poke the bear and get all of the comments from departments. I was trying to look for specific early comments that are in complicated areas like labor and employment, law enforcement records, provisions that relate to clerks and secretaries of policy bodies. So if people want to respond to that, if they want to say, sure, gut the entire ordinance or, do this, do that, fine, we'll read that. I would be surprised and pleased if we got more than 5 responses from the city. I think most people will say, until
I'm busy responding to records requests.
Yeah, either that or when this becomes legislation at the Board of Soups, I'm happy to respond to that. In the meantime, you guys just do whatever the hell you guys do over there. Whatever.
I'd rather hear, what areas confuse you.
Fine.
That's what I'm worried.
Anyway, the reason that we didn't include it in the packet is that we were not.
Well, I hadn't seen it, so.
Well, that too. So we can either make a motion to authorize you to send a letter, or even without a motion, I think you have the authority to send such a letter. This isn't taking any position on behalf of the task force or the committee. It's just, seeking early input. We will do, I think, plenty of engagement with city departments, members of the public, complainants, anybody with a pulse, et cetera. This was just.
I think this is more me
technical.
putting on the record and informing people that I, on behalf of the committee plan to do some outreach to city departments to seek input on what areas of the ordinance people find confusing or what areas of the ordinance they find confusing or would like to see clarification. And some of those things I think we've already gone over, but I think it'd be interesting to hear, especially if everyone comes back pointing out the same areas. I think that would validate what we're doing. Or if we've missed something that others find confusing, we can direct our attention in a more effective way.
And this
Question,
might,
please.
Yes.
I'm confirming that I will be taking no action with the document.
You will be, I mean, actually, I would recommend including it in the packet, just sort of for informational purposes, but this is not what I will be sending out.
how about we include the final, assuming that you send out a memo between now and the next meeting? I don't
Sure.
think the draft needs to be, we can keep the draft in a file somewhere, but I think for purpose of disclosure, it's the final letter that's, or memo that's going to supplant the draft.
Ms. Peterson, do you have additional thoughts on that, or?
I just want to know whether it's to be produced. I understand that it will be added to the file. Will it be produced in any format? In any form?
Yeah, in a form that is not this, yes.
A form that is not this?
Yes. When you say produced, do you mean what gets sent out, or for your tracking purposes, does it need to be produced?
For my tracking purposes, am I taking this document, entering it into the file for production in a packet at an agenda?
I think,
To be made public.
yeah, because I think otherwise you wouldn't take it. Like if we're not handing it to you to stick in a briefcase. Right.
That is my question, yes.
Yes. Yes. So, Member Pilpel, I think Ms. Peterson has to produce it.
My intention was to provide it for the file if anyone
That
is
means it needs to
listening.
be produced.
If anyone is listening and requests it, it can and should be provided, but I think this will be supplemented by the final
Right.
memo that you send.
Let me put it this way. Ms. Peterson has no other way of keeping track of it if she doesn't quote unquote produce it. Because it needs to be digitized.
Yes.
Yeah.
Fine.
So it will be received and scanned and
It's out
notices
there.
received
You got it.
Yeah.
at this meeting.
Yeah.
The question in my mind is, do we need to make a motion to authorize or direct you to send
No.
such a memo, or do you feel empowered to do that?
I feel empowered to do that already.
Fine.
Yes. So.
Feel free to send it to.
Actually, Ms. Peterson, maybe this would be, if you could please scan that, send it to all members of the committee and add it to the file, add it to this item on the file for next time, even if, I think just as a way of keeping track of it.
And attach it to the minutes.
Yeah, I think to this item.
This side.
Yeah.
Yeah.
And before we move on that, I would like to see if there's any public comment.
I have this other thing too,
Okay, but any public comment on
the memo.
the memo or our plan to send a memo? Okay, I'm seeing no public comment. Yes, Member Pilpel.
Okay, and then the last thing, speaking of handouts, this was something that I drafted back in November, based on the work that I had done to date.
So again, thank you for preparing this, since no one has seen it or reviewed it, and Member Wolf doesn't have it, I'd actually ask Ms. Peterson if you could do the same thing with this document. Let's scan it, produce it, send it to the members of the committee,
Right.
and add it to
The file. Okay.
for this item.
And I just wanted to explain briefly that this was an example, certainly not a final, of trying to summarize and capture what work might be involved in updating the ordinance. So someone who says, well, I'm not reading through 50 pages of thing right now. What are you kind of doing high level? That something like this And there was a version of this, I believe, on the San Franciscans for Sunshine website some time back, but somehow having a 1 or 2 page summary coming from the committee, ultimately coming from the task force, that we can share with people and say, well, this is what it kind of does. And then if they say, well, I need to see specifics, great, here's 50 pages of specifics. But at least this is intended to get people in the picture of what we're doing here.
Yeah, I think
and this is not the final.
No. And in fact, because we're not going to discuss it because nobody has seen it.
That's fine.
If Ms. Peterson can scan this as well, produce it, let's attach it to the file, and maybe we can discuss this at the beginning of this item before we even go into our line edits, because I think it could be a good sort of check and make sure we're all on the same page with, yes, these are the things that we're aiming to
Kind of like
consider throughout.
goals for the project.
Yeah.
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 Okay.
Any public comment? I'm seeing none. Oh, wait, we
No
do have
one
public
online.
comment. Yes.
Not on this specifically, but just taking a moment of privilege. In San Franciscans for Sunshine, excuse me, we hope to get Sunshine Ordinance, pardon my frog, hope to get Sunshine Ordinance amendments onto the ballot sometime in 2026. Okay. And what we're currently discussing, just for your information, is getting the actual Sunshine Ordinance amendments, keeping it at the administrative code level, onto the March ballot. And then, if we can do it, get a charter amendment dealing specifically with Ordinance Article Section 4, Ordinance Article 4. Getting that charter amendment on the ballot in November of 26. That's what we're aiming for.
So
Thank you. Actually, we have a question. Yes. So 2 different initiatives and a question to you, as long as you're here. Ms. Peterson had actually asked if we are working backwards in time. If you're looking to get something on the ballot.
We want the ordinance part of it, sections 1, 2, or articles 1, 2, and 3, and 4, at the administrative code level. We're aiming to get that onto the ballot, the primary ballot in 2026. And then a charter amendment dealing with the composition, appointments, et cetera, appointment system of the task force, changing it to a charter level commission. We want to get that on the November 2026 ballot. That's what we're currently looking at.
And just out of curiosity, because, we're working on similar things, but in different ways, when would you intend to start collecting signatures?
Well, in terms of the administrative code part of it, we're going to see if we can find 4 supervisors to sign off on it. As far as the charter amendment, we'd have to backdate it from whatever the deadline is. I don't have any specific dates in my head at the moment, but we'll just have to look and see what the time windows are on it and go from there.
Thank you for sharing these details with us. We appreciate it.
on that,
Yes.
I'll mention in a second under item 7, a brief thing about the commission streamlining task
Okay.
force.
I'd like to wrap up this item. So,
I understand. So all I wanted to say about this is I believe that in 2026, the primary is in June, not March. And so it's June and November. And the problem is that the deadline for introduction or consideration of a charter amendment for November is like by May. So you probably won't have the results of the June election in time to inform anything that's happening for November. So if you've got a November timeframe, just bear in mind that they don't mesh well.
Thank you.
Okay.
May 6th.
Okay.
Yeah.
Ms. Peterson, please, let's call the next item.
And no action taken.
And no action taken on 6, but it was a great discussion, and thank you everyone for powering through.
And to confirm, the next agenda will note that the discussion will begin at 67.26.
I'm going to double check, but I believe that was correct.
Okay.
Yep.
No one else is online.
Okay. So, Member Wolf?
Nope.
No. Okay. Next item,
Like
please.
dog's tail. Sorry.
Item 7. Announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
Does anyone have anything to add in this section? Member Pilpel.
Okay, so just briefly, as I said, I think I reported at the full task force meeting earlier this month, the commission streamlining task force that was created by Prop E that passed. They had their first meeting on Friday, January 31st. Their second meeting is in room 263 tomorrow at 2:00. I'm going to try to go. I submitted a detailed comment letter that may or may not be up on their website yet. I made clear in a disclaimer that I was not representing the task force. They were my own views, blah, blah, blah. I'm monitoring that closely for a variety of reasons, including what it may or may not do to us, what it does to the rest of the world, et cetera. And including that consideration of Brown Act public record sunshine requirements is a thing to be aware of as relates to the 100+ policy bodies that they're talking about keeping or nuking or merging or whatevering. But I just wanted members to be aware, and anyone who's listening, that I'm trying to follow that. It's about as obscure as things get around here, but it's pretty darn important both to us and et cetera.
You said tomorrow at 2 p.m. in which room?
Tomorrow is in 263. They're likely to adopt bylaws that would have them meet twice a month. And one of their meetings would be just before the full task force, our full task force meetings in this room at 1:00, first and third. So the first would be before ours. But anyway, we'll see how that all plays out. But they're starting their work, and they've got some aggressive deadlines to get stuff together, in part to affect ordinances and charter amendments for the 2026 ballot. That's how it all ties together.
Okay, thank you. Does anyone else have anything to add or future items? Member Wolf?
No.
Okay. Do we have any public comment? Okay. Seeing none, Ms. Peterson, please call the next item.
Item 8, adjournment.
Okay. All in favor?
So moved.
Aye, so moved. Thank you, everyone. I appreciate you all being here. And Rickney, thank you for joining us. We appreciate your input, and see you all next Wednesday.
We're adjourned at 9:30 p.m. Mics are off. Recording is going off.